adopted, a litigant has to adopt a way in which relief he wants. So he has not replied to that which relief he wants. Number one. Number two, now the entire case is revolving around the NIT. Now kindly takes the NIT at page 72 of GA3. Now kindly comes to page 76.
Yes.
Clause 49. May I read in a nutshell? All questions, claims, disputes or differences of any kind whatsoever arising out of or in connection with or concerning this contract at any time, whether before or after the determination of this contract, other than questions, claims, disputes or differences for the decision of which specific provisions have been made in the foregoing clauses of these conditions, hereinafter referred to as accepted matters, and shall not be reopened if attempted to reopen on the ground of any informality, omission, delay or error in the proceeding or any group whatsoever, shall be referred by the parties to a decision by sole arbitrator to be appointed. The notice regarding invoking of the arbitration clause shall be served by the registered post and addressed to Steel Authority of India, such and such claim and differences other than the accepted matters. So may I pause here for a moment? Kindly takes clause 44. Same page, first clause. Illegal unauthorized adverse report. If any staff of the contractor is caught in a theft case or in unauthorized movement of materials or in any activity which is punishable with law or not authorized by the plant, the contractor will bear full responsibility for the loss or other consequences which may result to the plant due to such illegal unauthorized act. Besides action to terminate the contract by the plant, the contractor shall also be liable for any act leading to banning of business. So my business has been banned. I came here before this court with the principal relief. My cause of action, paragraph 76 of the plaint, is on the only on the banning.
No, that's why they have taken this stand. You have come forward. It is the accepted matter. You have to go with an appellate authority, whatever it is. Now you have opened this. Now you have opened. Once you have to open, so accepted matter gone. As per
No,
the submission.
I will once there is an accepted matter. Accepted matter. I had also relayed when I was doing in the first lot first round before the lordship. Accepted matters is not at all arbitrable, and by a party consciously has made the matter non-arbitrable. So subsequently it cannot be made arbitrable and cannot be referred to arbitration. Number one. Now, my lord, kindly bear with me. Kindly comes to the work order which is annexed, because I will say this NIT.
No, because the kindly come to the paragraph 49.
49. Yes.
Third line, accepted matter and third line.
Yes.
And the decision on which the accepted matter according to the specific provision shall be final and binding on the parties to this contract and shall not be reopened if attempted to reopen on the ground of informality, omission, delay or error of the proceeding or in any other group whatsoever shall be referred to the parties hereto for the decision of sole arbitrator. So that's he has harping on that because
we have to read both the paragraphs.
Correct.
If read the second paragraph, the notice, will get the entire scenario.
Correct.
Because their contemplation is also that notice can only be given which are not accepted matters. So if I give them notice under clause 44, that is a non-arbitrable clause. So if conjointly reads both the paragraphs, I was also reading that while reading I was thinking, but it gets cleared up. The cloud is being cleared by the second paragraph. The notice regarding invoking of arbitration clause shall be served by the registered post and addressed to sale matters in question, disputes, claim, difference other than the accepted matters.
Correct. That's why, see, accepted matter, correct. But once the accepted matter, you again reopen. That's why what his submission is that accepted matter, he admits. This court also admits it is accepted matters. Once it is accepted matter, it is some other provisions. Correct. Once you again reopen that. So then again the matter has to be referred to the arbitrator. What is your answer
perhaps
to that?
that was
What is your answer? Because notice regarding invoking arbitration shall be served by the registered court so against the accept
other than the accepted.
correct. That is also referred to the paragraph 49 first part.
Yes.
But the second part is stated that in the accepted matter is reopened, so the arbitrator.
My endeavor will be that this NIT is not the NIT, and it's not at all the NIT which I am bound by. Why I am kindly comes to the work order.
So you are not challenge this.
No, I am no, I'm this was referred to in their opposition for the first time. Kindly comes to the work order. Page 81.
Page
81. I have taken the point in my reply.
Hmm.
Kindly comes to NIT number. It's down the middle.
And STS.
STA cases.
Correct.
Now come back to the NIT page 72.
Yes.
LTE cases. LTE cases are limited tender inquiry matters, and STA cases are different.
What is the STA cases?
STA cases, I tried to find the full form, but I could not find. But LTA cases I find is limited tender inquiry.
Limited
tender inquiry.
Yes.
Now, my submission before Lordship is that
what is the STA?
STA I could not found, but is definitely not limited tender inquiry. I have tried to search. I have also inquired with my clients. They could not also say what is STA.
Yes. What is the STA?
My lord, I have to take instruction. Lordship would kindly take up page 72.
72 I am there.
Left hand bottom corner.
Signature. That is different.
That is different.
That is different.
I am working with them for ages.
Okay, next.
I am working with them for ages.
Of course, my lord,
I am still now in other projects. I am working with them. Now,
no, but sometimes what happen? The NIT or the condition of contact will remain same, and the contact may different, and the condition of contract will be applicable to all the contracts. Every contracts will not having the separate special contract whatever. If they wanted, they can take the special condition of contract. But as per the even the CPWD manual, if a
in
contract
GCC also railways. But in those cases, entire nomenclature is getting changed in this.
Don't know that.
I also don't know on this, because I have inquired, because this is LTE cases. LTE I found limited tender inquiry, and my NIT says STA cases. So both the first letter and the last letter getting changed. T I can understand for tender. Now I have taken this point in my reply also. Yes. I pleaded this specifically. Now first, now this is the first reply, that this NIT is not binding on us. It's referring LTE cases, and this is regarding STA cases. Now, on the same sheet, page 81, Maidol will find that the second special remarks thereafter. Special remarks, same page 81.
Yes, page.
Same page 81.
Yes.
Special remarks, Milo will find next column. Now, kindly see all the scope, terms, and conditions of NIT number. A specific number is being provided.
Yes.
Now, kindly comes to page 72. I don't find this number here.
Terms and conditions of the NIT.
A number is provided.
Shall be applicable. Okay. Yes.
Kindly comes to page 72. At least this number is not being provided.
Yes.
Now, Milad, when I came for the first time before your lordship, I realized kindly takes Milad GA1 once. I came with Milad challenging the illegal banning because the banning was only our liner. You are banned, blacklisted. Reasons to be provided in separate sheet, nothing has been provided. Now, Milad, kindly comes to Milad the banning order at page 50
Of your J1.
of GA1. Or at page, well, before that, kindly takes Miller page 45. This is also part of the plaint. But I have read here from Miller, so Miller is referring. Kindly comes to page 45. This is their first banning for 6 months.
Correct.
First banning. Now, Miller, kindly read with me, Miller, kindly. Miller, since the allegations, third paragraph, since the allegations are of serious nature, it has been decided by SAIL, Bokaro Steel Plant, dealings with the company firm be suspended for a period of 6 months. This is the first banning. Now, Millard kindly turns to Millard, page 47.
Yes.
8/11/2023. Millard kindly takes Millard. It has been noted with the line starting. It has third line.
Yes.
It has been noted that the following irregularities, deception, fraud. I mean, I'm harping on the word fraud because this is also their case that I have committed fraud and those are of serious nature. So the law is settled with ISME and all those things. Fraud, somebody is alleging fraud of serious nature is not arbitrable. Now they cannot change the stand. If read jointly 45 and 47, serious misconduct and deception, fraud. Both are there later.
Yes.
Now, kindly turns the page. I was requesting your lordship to kindly come to page 50. This was the banning letter that I had banning order that I had come to your lordship on the first day. Page 50. It has been decided to ban future business dealing with JCC for the period of 3 years with immediate effect for reasons annexed here to nothing provided. Now, I got the banning guidelines. Page 52. Page 52 is the banning guidelines. And on the basis of this, I was banned. Now, this banning guidelines makes no reference to any arbitration clause or any jurisdiction clause. This has been settled by your lordship also, relying on the Supreme Court judgments of Inox and all those things, where a document which is the plinth of the matter, there has to be a specific reference, not vague reference, specific reference to arbitration and or the arbitration clause of another document.
So if you go by the appellate and this banning order, this guidelines.
Yes.
So how the suit is maintainable?
Because it's
without preparing an appeal.
Very well. Then I rely on Milad's first order of 31st July.
Correct.
But Milad had specifically held that I have claimed damages and this appellate firm cannot give me damages. For that reason, Milad is holding the suit to be maintainable and interim order was passed. Milad kindly comes to the Milad's order of 31st July. That is annexed, Milad, to my opposition to Milad GA3, and also in Milad's record is also there.
Yes.
Now, my lord, uh, page 5,
Yes.
internal page 5.
Yes.
Clause 10 of the guidelines provides for appeals, but the plaintiffs have not challenged the order of banning, but the plaintiffs have also prayed for decree of the amount due and payable to the plaintiffs by the defendants, as well as several other reliefs. And as such, this court is of the view the claim made by the plaintiffs with regard to the amount due and payable to the plaintiffs and the other reliefs as prayed for by the plaintiffs cannot be decided by the appellate court. So, no appeal. Well, this is a specific finding by your lordship.
Okay.
Well, this has reached the finality. So, I am
But you
protected
cannot
by
say
this.
this is a finality. This is the prima facie view of the court in the
मतलब prima facie view,
interim
then
application, any order is passed that
very well.
cannot be said that it
I'll
is
argue
final.
the same thing, before lordship. Then I have prayed for damages. If I have prayed for damages, clause 10, it would have been a bar if I would have filed a writ, alternative remedy. Section 9 of CPC does not bar any suit if there is no specific clause of bar.
With regard to damages is different. With regard, correct. But if in the guidelines it is provided the order passed by the authority can challenged. So
Yes.
whether it is not the bar that you cannot file the appeal and you cannot file the suit.
It would have been a bar subject to correction.
Cannot.
It would have been it would have been a bar alternative remedy if I would have filed a writ.
That is different thing.
Then I would have.
The very first day I
Yes.
put the question to you, why you not gone to the writ?
Absolutely. it would have been a bar because then I would have to show Whirlpool and all those things. This is not nowadays, it's not an absolute bar. Nowadays it's not. Supreme Court has opened that for us. That alternative remedy does not preclude. Even if I would have gone for it, this Miller would have stayed this.
Okay.
Even
next,
if.
Next.
Now, the appellate there in the banning guidelines, there is no specific bar for civil court. Like in non-obstant clause, which we have
that is not the case.
Yes. So, suit section 9 CPC, if it is not specifically bar like section 34 of Surface Act, that no civil court should entertain.
No, that has also been clarified.
That has also now been given. Now, suit is open for everybody. Suit is open. Now, of course, I cannot file a suit for IBC proceeding. But nowadays, we are filing suit to show to the court that there are pre-existing disputes. So, suit is door of suit cannot be closed at any point of time if there is no specific bar.
Okay.
And more so, I rely on this observation of your lordship, which is there page 5.
Okay.
Now, kindly takes So, I again come back to the issue that there is no reference of any arbitration clause in the banning guidelines. There is no reference of any jurisdiction in the banning guidelines. Cannot be.
Because if they cannot take the banning guidelines in the arbitration in terms of the accepted matter. Absolutely. They cannot take. They cannot take the two plead.
If that is so, I am protected by your lordship's own order that there has to be a reference of arbitration in the original guidelines.
Perfect.
That I rely on that. Even if I had showed also while arguing cursorily.
Next.
Now, if comes back to the second issue of this is what I have to say with regard to the arbitration. Now, the second issue is the forum selection clause. Now, I had said on the first day also, and it is my lord's observation also, that both are mutually destructive. And I am thankful to my learned friend. He has shown Justice Sabyasachi Bhattacharya's judgment. He must have skipped that. Thanks to him, the paragraph says that this type of arbitration clauses are not maintainable. This type of forum selection clauses. Now, I showed to your lordships on that day 49. If 49 is there, 50 cannot be there. So if 49 is there, you are holding 50. If you are putting 50, you are holding suit maintainable. If you are holding suit maintainable, 49 cannot be there. Well, that has been specifically observed by your lordship also in this order. Now, this is my first limb. Second limb is that, I have catena of judgments to show before Lordship. Kindly comes to page that clause 49 once, 50 once. GA3. Now, page 76. The contract shall be deemed to have entered into by Bokaro Steel Plant or Bokaro Steel City, and all causes of action thereafter be deemed to have been arisen at Bokaro Steel City, irrespective of location of the head or branch office of Steel Authority of India or the contractor. All kinds of legal proceeding against sale Bokaro Steel Plant in any matter out of the contract shall be tried only in appropriate civil court at Bokaro. Now, to this, if I go by this NIT, this is a NIT of 2022. Now, in 2022, every district had commercial courts. Every district. This plea cannot be taken that this was in 2012, like in railway case, 2002 GCC. So, civil court at Bokaro could not have received my suit at any point, could not have received my claim. There are judgments of Justice Sanjeev Banerjee when his judgeship was.
This is not your case. This is not your case that the Bokaro Civil Court, in the Bokaro there is no commercial court. That's why you have initiated.
No, this is not my case. This is my reply to their case. This is my reply. They have raised this in their opposition. This is my reply. I pleaded also in my reply that there are catena of cases of our High Court which says that the forum selection clause cannot be vague. It has to be specific. Now, if goes by this clause, then civil court which all is distinct from commercial court. Commercial court is defined in section 3, 2B, and read with section 6 of Commercial Courts Act. Civil court is different. So, if I strict to sense to go by this clause, then I would have to file a civil suit in the civil court.
Yeah, right.
Civil court cannot accept this claim.
Why?
Because this is a commercial anyway.
The district with the district which is not having the commercial.
Yes,
commercial
I'm coming.
The regular district judge or the regular civil judge senior division will accept.
Absolutely. Bokaro has a commercial court.
Then,
if Bokaro has a commercial court, the clause should have been commercial court at Bokaro. Because anyway, any claim arising out of this could not be simply a civil dispute. It's barred under 2(1)(c).
Sir, if a clause is given, jurisdiction of the matter will be in Calcutta. And if it is automatically, it is a commercial matter. It is necessary the commercial court at Calcutta.
I was trying to find out this. I found that this High Court has already laid that law.
What?
Yes, I have filed 3 judgments of Justice Sanjeev Banerjee, incidentally of him only. Where he has said that court at Delhi. In many areas, the court at Bombay. It has to be written which court. Which court? It can't be. In one of the matter, he has said that High Court at Bhubaneswar. He has held that there is no High Court at Bhubaneswar. There is High Court at Cuttack. So it can't be referred. I'll rely on the. I'll read this. I know Myler is curious of those judgments. I have found 3 or 4 judgments in the same line by the same judge. Now, civil court at Bokaro could not have entertained, any civil court could not have entertained this dispute. Because this could have been only entertained by a commercial court. There is also a judgment of Justice Shahidullah Munshi, unreported, of course. He said it should have been reported. It's a longish judgment, 17-18 pages. But he has also held, relying on Justice Banerjee's judgment, that referring court should be specific. It can't be vague. Even in this case, the referring court, the referred court is not proper. Civil court is different from commercial court. I take it that Myler has no quarrel on that issue. Because
no, that is not the issue. See. Okay, I will see the judgment. Yes. Then I
kindly comes to section 2B of Commercial Courts Act to show
Yes.
Commercial court means the commercial court constituted under subsection 1 of section 3. Now, kindly comes to section 3. institution of commercial courts. The state government may, after consultation with the concerned High Court, by notification constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under this act, provided that with respect to the high courts having the ordinary original civil jurisdiction, the state government may, after consultation with the concerned high court by notification, constitute commercial courts at district judge level, provided further that with respect to a territory over which the high courts have ordinary original civil jurisdiction, the state government may by notification specify such pecuniary value which shall not be less than 3 lakh rupees and not more than the pecuniary jurisdiction exercisable by the district court as it may consider necessary. Notwithstanding anything contained in this act, state government may, after consultation with the concerned high court by notification, specify such pecuniary value which shall not be less than 3 lakhs rupees or such higher value for whole or part of the state as it may consider necessary. Now, this goes on. Now, kindly turns to 6. Jurisdiction of commercial courts. The commercial court shall have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested territorial jurisdiction. So, the commercial courts are not civil courts. So, I would have accepted this clause that it was promulgated or formed before 2015. Then I would have no case, because at that point of time people could not have foresee that Commercial Act is going to come. But this is of 2022 document. I take it SAIL who are guiding the SAIL are of having substantial knowledge. There is an act which is called Commercial Courts Act, and any 21C again and I am also protect 21C carriage of goods 21C Roman 5 XV 17. These are the two and also there is no quarrel that this is not a commercial dispute. So this court, civil court, could not have received my suit. So the referring court is improper. Now I will first start with those judgments of Justice Banerjee and also Justice Munshi. No, let us start with my law's judgment. It is 2024 SCC Online Calcutta 3590. Yes. যেগুলো কপি আছে আমি তোমাকে দিতে থাকছি। হ্যাঁ, দাঁড়াও, এটার কপি আছে। না, আমি কপি দিই না, তুমি বলছো। Kindly takes my law's judgment. Paragraph 4. I found this case much more similar to our case. Kindly comes to paragraph 4. The defendant submits that the work order clearly makes the GCC SCC technical specification as the documents forming the contract. The defendant says that as per the contract, the parties have chosen arbitration as the mode of resolution of the disputes between the parties, and thus the parties to the suit should be referred to the arbitration. Then 5. The defendant submits that this court has no jurisdiction to deal with and decide the instant matter, as the contract specifically provides that the courts in Mumbai shall have exclusive jurisdiction in all matters arising out of the contract. Then paragraph 9. 9-10 set out the work order. The entire work order is set out by your lordship. Then kindly come to 13. Kindly takes page 8, settlement of disputes, adjudicator 6.1.1 and 6.2, page 8 of the judgment.
Yes,
the set out part. So arbitration clause has set out. Now kindly takes to paragraph 13. The issue is no more res integra. The provision of subsection 5 of section 7 of the Arbitration and Conciliation Act have been considered by Honorable Supreme Court in MR Engineering. After considering the relevant passages from Russell on arbitration and various English judgments, this Honorable Supreme Court held thus. Then may I read paragraph 24, 1, 24 Roman 1, the contract should contain a clear reference to the documents containing arbitration clause. The reference to the other document should clearly indicate an intention to incorporate the arbitration clause into the contract. The arbitration clause should be appropriate, that is capable of application in respect of the disputes under the contract, and should not be repugnant to any terms of the contract. When the parties enter into a contract making a general reference to another contract, such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. The arbitration clause from another contract can be incorporated into the contract where such reference is made only by a specific to the reference to the arbitration clause. Where a contract between the parties provides that the execution or performance of that contract shall be in terms of another contract, which contains the terms and conditions relating to performance and a provision for settlement of disputes by arbitration, then the terms of the referred contract in regard to execution performance alone will apply, and not the arbitration agreement in the referred contract unless there is a specific reference to the arbitration clause. Now, may I come back to my lord's observation in paragraph 14. It could thus be seen that the Honorable Supreme Court has held that when the parties enter into a contract making a general reference to another contract, such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. It has been held that the arbitration clause from the contract, another contract, can be incorporated into a contract where such reference is made only by a specific reference to the arbitration clause. It has further been held that where a contract between the parties provides that the execution or performance of that contract shall be in terms of another contract, which contains the terms and conditions relating to performance and a provision for settlement of disputes by arbitration, then the terms of the referred contract in regard to execution performance alone will apply, and not the arbitration agreement in the referred contract unless there is a specific reference.
Correct.
Now, Miller 15, my lord had proceeded with Miller. Now, Miller kindly comes. So, Miller ultimately 20. Miller dealt with Inox Miller, and Miller 20, in view of the above, this court finds that neither the arbitration clause nor the forum selection clause are applicable in the case of the plaintiff, and thus the matter cannot be referred to arbitration.
Yes.
So, Miller, my contention is also the same before your lordship.
Yes.
Now, Miller, next, Miller, the point of that 2000 2009 SCC online Calcutta 2533. তোমার কপি আছে
Yes.
well, this is one of those judgments, Miller. This is an application for revocation of leave under clause 12 of letters patent in the alternative for dismissal of the suit in the further alternative for the plaintiff to be rejected, same in our case. The first defendant applicant says that no part of the plaintiff's alleged cause of action against the first defendant has arisen within jurisdiction, and that it would be the evident that the plaintiff does not have any cause of action against the first defendant, and the plaintiff does not disclose any. No case has been made out for revocation of leave on the ground of balance of convenience. The first defendant carries on business in Howrah, which is just across the river. The averments in the plaint demonstrate that a part of cause of action has arisen within jurisdiction. The claim of the plaintiff is that the third defendant colluded and conspired with the first and second defendants to cause credits to be reflected in the accounts between the plaintiff and the first and the second defendants. It is averred in the plaint that the first and second defendants' accounts with the plaintiff showed more payments than had been actually tendered by such defendants. Particulars of fraud is pleaded. I mean, kindly similar, the first defendant has also relied on a forum selection clause contained in the bills that were raised by the plaintiff on the first defendant. The relevant clause is that in the case of legal dispute, the forum shall always be Mumbai. The dispute that is referred to in the forum selection clause would be qua the individual bill. In any event, the forum selection clause, notwithstanding its use of the word always, is vague, and in the sense that it does not specify the particular court in Mumbai that would be exclusively entitled to receive any action in respect of the bill. Further, the plaintiff's cause of action is on account of alleged fraud committed by the defendants upon colluding and conspiring with each other. The plaintiff's claim is not founded merely on bills or the bills raised by the plaintiff on the first defendant, but further the plaintiff's action against the other defendant will not be the subject to the forum selection clause. There is no merit in the application, neither can be leave granted under the clause 12 be revoked on the basis of the above made in the plaintiff. So Millard, my case is that Millard, that my banning clause, my banning guidelines had not referred to any clause. Even if Millard takes para 50 of NIT, which Millard according to me is not the proper NIT, Millard, it's a vague clause because civil court at Bokaro standing in 2022 could not have accepted my suit because it's a commercial. Now, Millard. Next is Millard 2008 to CHN, page 28. Millard, this is again even revocation of clause 12. These are all different matters, but out of the same court. This is an application for revocation of leave granted under clause 12 of latest patent. Three grounds have been urged: that no part of plaintiff's cause of action arose within the jurisdiction of this court, that the forum selection clauses in the plaintiff's invoices require the suit not to be instituted before this court, and as an alternative to the first ground, that the balance of convenience is against the continuation of the suit in this court. Millard kindly comes to Millard paragraph 4. The defendant relies on two invoices appended to its affidavit in reply. Such invoices raised by the plaintiff have two different forum selection clauses. The invoice of May 20, 1998 has following line printed on the foot of it: subject to Delhi jurisdiction. Another invoice of 4th March 1919 has it to say subject to Bombay jurisdiction. The defendant asserts that the plaintiff is bound by forum selection clauses in his invoices, and whether it is Delhi or Bombay that the plaintiff would have chosen as the forum, Calcutta is certainly not the forum, in consonance with the fine print in the plaintiff's invoices. Now, Miller kindly comes to paragraph 90. Miller, several judgments are being referred to and quoted. 19. A forum selection clause acts as an ouster upon conferment of authority to a chosen forum. The ouster is merely a consequence. The ouster is not the cause, but only the effect. The cause is the identification of a forum that the parties had agreed to go to. If the identification is not possible, then there is no cause and consequently no effect. Loosely speaking, the ouster of a court by a forum selection clause is by specific performance of the parties' bargain. Vagueness or conflict as to the import of a clause is anathema to this specific performance. This defendant does not suggest that it is Delhi clause which is the one to be enforced, or that the Bombay clause which is the one that binds the parties. All that this defendant says, it is to be relieved of Calcutta for the conflict between the Delhi and Bombay clauses to be resolved later. It is only the ouster that the defendant stressed upon. This is not an argument that can be countenanced. There is another aspect the defendant has completely overlooked and has failed to address on. A forum selection clause is enforceable provided designated forum would otherwise have authority to receive the action. I am on this. So the designated forum, a civil court at Bokaro, has no authority to receive this suit. Now, the unreported judgment of Justice Shahidullah Munshi. It dealt with many. Page 9. Kindly comes to page 9.
Yes.
Mere reference, the last paragraph.
Yes.
Mere reference of the terms and conditions contained in the NIT, it is not itself incorporation of the agreement, and it cannot be said to be agreement between the plaintiff and the defendant. Therefore, the stipulation mentioned in the terms between the plaintiff, mentioned in the terms and the conditions of NIT is not applicable to the plaintiff if at all. It is applicable in between northeastern coalfields and the defendants. Now, Mr. Banerjee, however, submits that the decision relied upon by Mr. Kaur in MR, my lord has also relied on this. MR engineer squarely purports his case where the Honorable Apex Court has held in paragraph 33 that in absence of a clear or specific identification that the main contract is entirely including the arbitration agreement was intended to be made applicable to the subcontract between the parties, and has the wording of subcontract discloses only an intention to incorporate by reference the terms of main contract relating to the execution of the work as contrasted from the dispute resolution, we are of the view that the arbitration clause in the main contract did not form the part of the subcontract. The above finding of the Honorable Apex Court is sufficient to support the contention made by the plaintiff that the doctrine of incorporation as urged by Mr. Kaur has no manner of application in the present case, and that simply while giving reference to the terms and conditions of NIT is not sufficient to hold that the entire terms and conditions are binding between the plaintiff and the defendant, between the parties and the MOU dated such and such irrespective of its place of execution. In addition, Mr. Kaur has further submitted that he tried to argue that in the view of clause 32.1, NIT, the suit ought to have been filed before Guwahati High Court. Incidentally, Guwahati High Court has no original said jurisdiction, and therefore suit cannot be filed before the Guwahati High Court. In the midst of his submission, Mr. Banerjee relied upon, this is again of Justice Sanjeev Banerjee's judgment, which also dealt with the jurisdictional issue in an identical fact based on an agreement between the parties containing clause, quote unquote, the quotation starts, all matters arising in connection with the agreement shall be settled by the courts within the jurisdiction of Bhubaneswar High Court at Orissa. In that decision, his lordship held that there is no high court in this country by the name of Bhubaneswar High Court. However, his lordship held that to start with this is no high court in this country by the name of Bhubaneswar High Court. Even if one were to ignore such minor matter and consider the clause to imply the Orissa High Court at Cuttack, it would still not be forum selection clause conferring exclusivity on any specific court as is ordinarily required for a forum selection clause to be effective. The Orissa High Court has no original jurisdiction, and as such, the forum selection clause could not have been provided that only Orissa High Court would have the exclusive authority to entertain petitions arising out of the agreement. So, in the same case that I am running before your lordship. Here we have this identical situation where, although according to Mr. Kaur, suit ought to have been filed before Guwahati High Court, but Guwahati High Court has got no original jurisdiction, and so it is impractical to file a suit in that court. Those apart, Mr. Banerjee relied such and such and such, all of this. Now, kindly comes. The next page, the NIT clause is set out in italics. Now, then comes to page 13. Page 13. Plaintiff has filed a suit purely on the basis of rights and obligations created under the MOU, and in pursuance thereof, the plaintiff has filed a suit contending that there has been breach of the terms of said MOU. In paragraph such and such, the plaintiff has demonstrated the cause of filing of the suit. On an analysis of the averments made in this paragraph, it does not raise any doubt in the mind of this court that part of cause of action has not arisen within the jurisdiction, has arisen. Whether or not the averments made in those paragraphs are correct is yet to be decided. It should be has arisen. Otherwise, it doesn't run any meaning. Those are all tribal issues. May I pause there? This is exactly Milas has held on 31st July. The same point was raised. Jurisdiction clause, Milas held, these are tribal issues. Now, court must give emphasis at this stage upon the averment made in the pleadings, and is for the determination of the issue whether a plaint should be rejected under the provision of Order 7 Rule 10 of CPC. Court is not required to traverse through the documents other than the plaint at this stage. From the plain reading of the plaint, it is sufficient that the plaintiff has been able to show that the exact part of cause of action within the jurisdiction of Calcutta High Court. Therefore, there is no reason to reject and or return the plaint.
Yes.
Well, this is exactly my lord had held. My lord, my learned senior friend was not there. His junior was there. He has argued this at length for 2 days. That Miller, this court has no jurisdiction. My lord had held that Miller, the parties are within the cause of action because the letter of Miller banning, first banning came to me within, second banning came to the order came to me within. So Miller, this court has the jurisdiction. Now, Miller, coming back to the Miller, the case of Miller accepted clause. Yes. Miller, I am relying on 2023-13 SCC. No, 2023-13 SCC, page 661. Ready. I mean, it kindly takes Millet feeling aggrieved, the first paragraph, feeling aggrieved and dissatisfied with the impugned judgment passed by High Court at Delhi, such and such, by which the High Court, in exercise of powers under Section 11, subsection 6 of the Arbitration Act, has appointed arbitrators to resolve the disputes between the parties. The original respondent, Emars India, has preferred the present appeal. Now, kindly comes to 4. The respondents herein approach the High Court for appointment of the arbitrators in terms of clause 37 of the addendum agreement by submitting an application under section 11(5) and 6 of the Arbitration Act seeking appointment of arbitrators by the court. The said arbitration petition was opposed by the appellant wherein, by raising various grounds, including one of the grounds that the dispute falls under clause 36 of the addendum agreement and not under clause 37, which incorporates arbitration clause. Despite having noted that clause 36 of addendum agreement stipulates that in the event of any dispute with regard to clauses 3, 6, 9, other parties shall have a right to get the agreement specifically enforced through appropriate court of law. The High Court has appointed the arbitrators in terms of clause 37 of the addendum agreement by observing that conjoint reading of clauses 36 and 37 makes it clear that the parties does not have a right to seek enforcement of agreement before the court of law, but it does not bar settlement of disputes through Arbitration and Conciliation Act. By observing so, the High Court has allowed the application under section 11(6). I mean, it kindly comes to paragraph 8.3. 8.2. The learned counsel appearing on behalf of the appellant submitted that as observed and held by this court in such and such, the appointment of an arbitrator may be refused if the arbitration agreement is not in writing or the dispute is beyond the arbitration agreement. 8.3. The learned counsel appearing on behalf of the appellant has further relied on Briddha Drolia. Then 8.4. The learned counsel relied on Indian Oil Corporation. Last line, of preliminary inquiry is permissible if the dispute is raised with respect to arbitrability. Now, kindly comes to paragraph 12. The dispute resolution jurisdiction clause is being set out. Now, see clause 37. In case of any conflict or difference arising between the parties, or in case either party refuses or neglects to perform its part of obligation under this addendum collaboration agreement, inter alia as mentioned in clause 3, 6, and 9 herein above, then the other party shall have every right to get this agreement specifically enforced through appropriate court of law. Then 37 is the arbitration clause. So I take it 36 is the accepted matters. Now 14. In Oriental Insurance Company, it is observed that held by this court that the parties are bound by clauses enumerated in the policy and the court does not transplant any equity to same by rewriting a clause. It is further observed and held that an arbitration clause is required to be strictly construed. Any expression in the clause must unequivocally express the intention of arbitration. It can also lay the postulate that in which situation the arbitration clause cannot be given effect to. It is further observed that if a clause stipulates that under certain circumstances there can be no arbitration and they are demonstrably clear, and then the controversy pertaining to appointment of arbitrator has to be put to rest. Now, kindly comes to paragraph 19. On the question who decides on non-arbitrability of the dispute after referring to and considering earlier decisions on the point, more particular the decisions all the decisions are recorded, then that the question of non-arbitrability relating to inquiry whether the dispute was governed by the arbitration clause can be examined by the courts at the reference stage itself and may not be left unanswered to be examined and decided by arbitral tribunal. Thereafter, in paragraph 153, it has been observed and held that the expression existence of arbitration agreement in section 11 of the Arbitration Act would include to aspect validity of an arbitration agreement, albeit the court at the reference stage would apply the prima facie test. It is further observed that in cases of debatable and disputable facts and goods, reasonably arguably cases, etc., the court would force the parties to abide by the arbitration agreement, as the arbitral tribunal has the preliminary jurisdiction authority to decide the disputes, including the question of jurisdiction non-arbitrability. Now, Vidya Drolia is being quoted. Now, kindly see paragraph 21. In Vidya Drolia, it is specifically observed and held by this court that rarely as a demurrer the court may interfere section 8 or 11 stage when it is manifestly and ex facie certain that the arbitration agreement is non-existent, invalid, or the disputes are non-arbitrable. Though the nature and facet of non-arbitrability would to some extent determine the level and nature of judicial scrutiny, it is further observed that the restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and cut to off the deadwood. It is further observed that the prima facie review at the reference stage is to cut the deadwood and trim off the side branches and straightforward cases where dismissal is barefaced and pellucid, and when on the face facts and the law, the litigation must stop at the first stage. Applying the law laid down in this court in the aforesaid decisions, considering clause 36 and 37 of the agreement, and when a specific plea was taken by the dispute falls within clause 36 and not clause 37, and therefore the dispute is not arbitrable, the High Court was at least required to hold a primary inquiry, review, prima facie come to a conclusion on whether the dispute falls under clause 36 or not, and whether the dispute is arbitrable or not. Without holding such inquiry, and despite having observed that a party does not have a right to seek enforcement of agreement before the court of law as per clause 36, thereafter has appointed the arbitrators by solely observing that the same does not bar the settlement of dispute through arbitration. However, High Court has not appreciated and considered the facts in the case of disputes as mentioned 3, 6, and 9 for enforcement arbitration agreement. The dispute is not arbitrable at all. In the view of the matter, the impugned order is permanently set aside. So, in this case, the clause 44 falls within accepted clause, and any reference in that regard will be accepted, that is non-arbitrable. Now, the I 2014 9 SCC 246 এটা কপি দিয়ে দিচ্ছি, paragraph 19, only one paragraph.
On which point?
The accepted matters. If a paragraph 9, only one paragraph. 19 19.
Yes.
If a non-arbitrable dispute is referred to an arbitrator, and even if an issue is framed by the arbitrator in relation to such a dispute, in our opinion, there cannot be a presumption or a conclusion to the effect that the parties have agreed to refer the issue to the arbitrator. In the instant case, the respondent authorities had raised an objection relating to the arbitrability of the aforestated issue before the arbitrator, and yet the arbitrator has rendered his decision on the quote-unquote accepted disputes. In our opinion, the arbitrator could not have decided the accepted dispute. We therefore hold it was not open to the arbitrator to decide the issue which were not arbitrable, and the award, so far as it relates to disputes regarding non-arbitrable dispute is concerned, is bad in law and hereby quashed. So, even if this is referred to, the arbitrator cannot proceed with this. Should I come back?
How much judgment you are having?
I have these judgments to show.
Come next day.
I have also deal with their judgments.
Sense offering for the plaintiff, sense offering for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter appear on
Any time may be fixed, then we can be.
time can't matter appear on 4th April under the same heading and under the heading adjourn motion.
It is a new motion. My lord had kept his new motion today, so that it can.
No, especially fix. Today is especially fix.
But can it come as new motion like the today? Today it was kept by lordship as because we are on the verge of.
No, especially fix matter. Today is a specific.
Well, my lord, then my lord extend the interim order expiring on 28th.
28th March.
Yes, 28th March.
Counsel for the plaintiff submit that interim order granted early is going to be expired today and prayed for
28th.
Expiring on 28th of March
March.
2025 and prayed for extension of interim. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 8th of April 2025 or until further order, whichever is ordered.
Before your lordship takes the testamentary matter, item number 14, this matter, your lordship heard it for at least 3 days. If your lordship today in second half, I am having some personal difficulty. So if takes it tomorrow, I don't have any problem.
Tomorrow there will be no commercial matter.
But this is a recalling matter, in respect to your lordship has heard it, in respect to the service. So it is basically a part-heard matter.
I don't know.
Mr.
Who is for the other?
Miss Cheyoshi Das is appearing and Mr. Shumon Dattu is learned senior.
No, I don't know. After lunch it will be taken because all fixed matters are
yes,
there.
yes, for that reason, because I have some personal difficulty in second half. Otherwise, I would not have prayed before.
Record and order 14.
Well, I'll inform them.
14. So offering for the you are for the defendant?
No, yes, I'm for the plaintiff. Opposite respond.
Police, as per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on
Friday, my lord.
On 4th of April.
Well, if lordship can take it on Friday, my lord.
No, Friday commercial.
Next.
Well, instead of 4th, can it be 7th? Subject.
You are
7th.
पहले वाला है ना? Earlier matter ना?
7th.
Where is the other
Yes,
side?
there.
Earlier जो है instead of 4 7.
7.
उससे पहले वाला. First one.
Instead of 4th, 7th.
7. ठीक है? 7th.
Published.
This is my application, my lord, for letters of administration.
Yes.
My lord, this is my application for letters of administration, my lord. I paid ad valorem duty, my lord. All formalities have been completed, my lord. And only, my lord, kindly dispense with the chapter 16 rule 23A, my lord, sub rule 2.
For what?
My lord, for drawing up and complete, my lord.
Where is the will?
My lord. There is no will, my lord.
What is it? Letters of administration?
Letters of administration, my lord.
Who is the petitioner?
Petitioner is the son of the deceased.
Subhasis Mukherjee.
Yes, my lord. Other son has died.
Who is the deceased? Pranti Mukherjee.
My lord. Pranati Mukherjee is his mother.
Where is the legal? Where is the death certificate?
Death certificate, my lord, I have
Died
annexed.
on 21.
Yes, my lord.
Okay. And home, where is the legal year?
Legal years, my lord, two sons.
Hmm.
One son has died on 27th April 22, my lord. I have amended, my lord. And
What about the husband?
husband predeceased, my lord, died on 23rd February 1999. And I have annexed the death certificate also, my lord, with the probate application.
There is no other legal year.
No, my lord. Only the petitioner, my lord.
Then?
And I have amended the pleadings, my lord. All have done, my lord. I have paid ad valorem duty, my lord.
Ad valorem could be paid.
My lord, paid.
When you are paid?
My lord, in this month, my lord, certificate has been issued, my lord.
Where is the affidavit of assets? What is the total value of the asset? 76 lakhs.
Yes, my lord. I have amended the asset, my lord.
The petitioner has filed the present application for grant of letters of administration to the estate and credits of the deceased Pranati, Pranati, P-R-A-N-A-T-I, Pranati Mukherjee, who died on 9th of May 2021, leaving behind two sons, that is the petitioner herein, namely Subhasis Mukherjee and another son Shubhankar Mukherjee. Counsel for the petitioner submit that the husband of the deceased was predeceased to her, who died on
23rd February
1999. The out of the two sons, one son Subhankar Mukherjee died on 27th of April 2022. Accordingly, the print 2022 during the pendency of the present application. Consider the submission made by the counsel for the petitioner. Peruse the application. This could find that there is no impediment to grant letters of administration to the petitioner to the estate and credit of the deceased having effect within the state of West Bengal, subject to furnishing the personal bond of rupees 7 lakh with two sureties. The department is directed to क्या बोला ऊपर क्या बोला full stop. The department is directed not to draw and complete the order. PLA number this.
I'm grateful.
Next.
I'm for the petition amendment. This is a non-contentious probate application. An executor, petitioner is the named executor.
Where is the will?
Will is at page 16, my lord.
Who is the testatrix?
Testatrix.
What is the name? Purnima
Mazumdar.
Yes. Where is the name of the testator executor in the will, sir?
Executor, my lord, very next paragraph, it was stated, I am a spinster and living alone. The Khokon Bodai, son of Mahadev Bodai, whom I know from his childhood, and I have great love and affection for him. Further, he has been looking after my property since long back. Khokon Bodai is the executor, my lord. He is the
Where is the executor? Where is the name? Where is the, we have been appointed executor?
last paragraph, my lord. First page, last paragraph. I hereby appoint said Khokon Bodai, son of Mahadev Bodai.
That's why I'm asking you.
Yes, madam.
Executor. When he died, when she died?
5th of August 2000, my lord.
Where is the death certificate?
At page 15.
5th August 2000.
5th of
Yes.
August 2000.
What is the date of the will?
Date of the will?
99.
Yes, my lord. 26 June 1999.
And when you file the application, 2022. After 22 years, where is the explanation? After 22 years of the will, where is the explanation, sir?
It has been
So, how many legal years? So there's no explanation how after 22 years the probate can be granted.
my lord, I have to take instructions from this.
As per, so appearing for the petitioner. As per the prayer made by the counsel for the petitioner, the case adjourned. Let the matter appear on 8th April. Next.
May it please, my lord, I appear for the executor in this matter. My lord, in this matter, my lord, the attending witness had proved the execution of the will because the attesting witnesses have died. My lord, the attending witness had deposed, but my lord, while deposition, he has identified the signatures of the testatrix as well as the attesting witnesses, but they were not marked as exhibits.
Hmm.
Lord, I have brought my witness. Lord, I just, with Lord, in his presence, my lord, may the document as well as the
Where
signature.
is that?
Lord, at question number 16, your lordship may kindly seize. He has identified the thumb impression of the testatrix. And question number 18, read with 19, 20, and 21, he has identified the signatures of the
Page
attesting
number,
witness.
question number?
Question 17.
Are you in person or identified thumb impression opening? Consistency, yes, the witness encircled.
14 and 17 is the LTI of the
LTI
testatrix.
will not go. What about the signature of the attesting witness?
At page, Lord, sorry, question number 18 to 21. Your lordship had also asked him two questions.
18.
18 to 21, my lord.
Please encircle the witness thumb impression. That is thumb impression.
Yes,
Where is
my
the
lord.
witness of the?
21.
Please encircle identification of the witness. This is a single, sir. Yes.
So, my lord, in view of the identification, my lord, may the
Bring the witness.
Lord, do I need to put further questions or, my lord, the document will be marked?
No.
What is the name, sir? Soumen Dev.
He's already on.
Soumen Kumar Dev.
Yes, sir.
PW1.
MEN
Yes.
আপনাকে বলছি ম্যাডাম
Dev. DY.
Okay. PW1 is examined in recall. Examine on recall. Yes. Where is the will?
My lord, the original will is with the probate application, my lord.
There.
Pagination তো করা নেই। Page কোথায় থেকে 12 বলছেন আপনি? ওর নাম কি আছে?
Show the signature of the attesting witnesses in the will.
Page
Shown.
ম্যাডাম হ্যাঁ
Shown the original will to the witness.
ঠিক আছে। Okay. ঠিক আছে।
Put the question.
yes নাম কি ছিল সৌমেন দাস দে সৌমেন দে Mr. De, in view of your answers to question number 14 and 17, please tell my lord whose LTI
No, that is LTI will not do. That is LTI. Okay. With
Very
regard to 21 only.
in view of your answer to question number 21, please tell the names of the signatures whom you have identified on the last occasion.
আপনি কার কার সিগনেচার আইডেন্টিফাই করেন?
হ্যাঁ, এবারে এখানে যিনি আছেন বিদ্যুৎ দত্ত, উনি এটা লিখেছেন, আর রঞ্জিত মিটার হচ্ছেন
বিদ্যুৎ দত্ত
হ্যাঁ,
লিখেছেন মানে
এই লেখাটা, হ্যাঁ লেখাটা ওনার
বিদ্যুৎ দত্ত
Leave it. Can you identify the signature of the attesting witness in the will?
ইয়েস, এই যে হ্যাঁ, এটা রঞ্জিত কুমার মিটার, উনি রঞ্জিত কুমার মিটার অ্যাডভোকেট, উনি এটা ইয়ে করে সামনে ছিলেন, এবং বিদ্যুৎ দত্ত উনিও ছিলেন।
What you are doing, Mr. Interpreter? Court has put the question. Court has not asked. Question has been completed. So why you are taking the answer? Can you identify the signature of the attesting witness in the will? Yes or no?
হ্যাঁ, ওনার এটা সিগনেচার।
Who are the attesting witnesses?
রঞ্জিত মিটার এবং বিদ্যুৎ দত্ত।
Ranjit Meter and Vidyut Dutt.
Can you identify the signature?
ইয়েস, হ্যাঁ, আমি চিনতে পেরেছি, আমি ছিলাম।
Yes, I can identify. I was there.
Where is the signature of Ranjit Mitto?
Ranjit Mitro's signature কোথায়?
এটা উপরে আছে, 1 নম্বরে আছে।
The first one is the signature of Ranjit Mitro.
Will is marked.
No, my lord, will is also not marked. Everything was identified. Your lordship had said to mark it, but it was not marked on the last occasion.
You persons are belonging to a big chamber.
Lord, it was. Your lordship had dictated to be marked, but inadvertently it was not marked. Your lordship may kindly seize the last
So
order.
what is your duty?
It was, Lord.
उससे पहले जो सिग्नेचर वाले से पहले जाओ, first question. Can you identify the will?
ইয়েস, হ্যাঁ, এটা ওনার এর উইল আছে, রসনাবালা দাসের উইল আছে।
This is the will?
হ্যাঁ,
Yes, this is the will.
Yes, this is the will.
The will be marked as Exhibit A. Next job is where you left the signature, na?
যেখানে সিগনেচারটা আপনি উনি যেটা আনসার দিয়েছেন,
Last answer. Yes. Signature Ranjit Mitra is marked as Exhibit A by 1. Yes, next. Is there any signature of the another attesting witness?
আর কোনো অ্যাটেস্টিং উইটনেসের সই আর দেখতে পাচ্ছি
না, এই একটা রয়েছে,
রঞ্জিত মিত্র ছাড়া সে বলছে
রঞ্জিত মিত্র ছাড়া রসনাবালা ইনি করেছেন। নো, বিদ্যুৎ দত্ত আর
Is there any signature by another attesting witness?
No.
অন্য অ্যাটেস্টিং উইটনেস
Gone.
না, এই বিদ্যুৎ দত্ত
Lord, he has answered on the.
Court cannot help more than this.
May I ask him, Lord? On the last occasion, may I ask him, Lord? Shown page 2 of the will. Please tell my lord, apart from Ranjit Kumar Mittal, who else had signed the will?
1 নম্বরে আছেন, আর
এক নম্বরে আছে, এক নম্বর মিত্রে আছে তো
বিদ্যুৎ দত্তর আছে।
And there is another signature of Mr. Vidyut Dutt. Are you in a position to identify Mr. Datta's signature?
হ্যাঁ, আমার সামনেটা করেছেন প্রেজেন্ট।
Yes, I can identify. He had signed in my presence. Now, Lord, may the signature be marked as A by 2.
Signature of Vidyut Datta is marked A by 2.
Yes. Lord, may he be discharged. Will and the signature is marked.
Yes.
ঠিক আছে,
Lord, the witness has also identified the LTI of the
That's
testatrix.
already taken identification, but it cannot be marked. How the LTI be marked?
Very well, Lord. Now, Lord, may the
Encircled.
he has
Cannot be
encircled in
marked.
red pencil.
Whether the LTI can be marked? How it can be marked? LTI cannot be marked.
As far as
If it is put in the presence of the attending witness, it can be marked.
as far as I'm Lord, I also know that it can be marked, but if it's falling from my Lord, Lord, I should.
Yes.
Lord, may the witness be discharged.
Thank you.
Lord, may kindly take the application, Lord. Lord, application for grant of probate of the last will of the
Hmm.
testatrix dated 31st of August 1993.
Hmm.
The original will is there, my lord.
Hmm.
The attesting witnesses both have died,
Hmm.
and my lord, the husband of the testatrix had predeceased her
How you can say they both have died
because, my lord, their death certificates are annexed, my lord,
of
of the two attesting witness.
where it
That's
is?
at page 10 and page 11.
Okay.
Ranjit Kumar Mittal and Bidyut Datta.
Yes.
And my lord, the husband had also predeceased her on 17th of July 1982.
Hmm.
That death certificate is at page 12 to 13.
Hmm.
And the legal heirs, my lord, there are the testatrix was issueless. There were three legal heirs, her sister's son,
Hmm.
out of which, my lord, two have given no objection and one is the executor. That's at paragraph 6.
Who have given no objection?
Yes, my lord, they have given no objection. Their affidavits are there. I'm
Yes. Then
Yes, my lord. I'm Lord. The prayer in terms of prayer C had already been given, Lord, on 8th of March 2024. Prayer B and C. Now, my lord, no caveat has been forthcoming, my lord. I'm praying for grant of probate.
so appearing for the petitioner. Petitioner, one witness is present on recall. During his examination, the witness has identified the signature of the attesting witness, identified the will, which is marked as Exhibit A, and also identified the signature of the attesting witnesses, which are marked as Exhibit A by 1 and A by 2. Counsel for the evidence of the plaintiff witness is concluded and witness is discharged. Number next. The petitioner has filed the present application praying for. Where is the explanation?
Lord, last paragraph, my lord, at para 13 at page 5.
The petitioner has filed the present application for grant of probate of the last will and testament dated 26th of June 1982 of the testatrix Rasana Bala Dasi, RASANA Rasana BLA Bala Dasi, DASSI Dasi.
Alias Rasana Bala Bhandari also.
It is not in the will.
In the death certificate is there.
Rasana Bala Dasi alias Rasana Bala Bhandari, BHANDARI. Counsel for the petition submit that the testatrix has executed her last will and testament by appointing the petitioner as sole executor of her last will and testament in presence of two attesting witnesses. But full two attesting witnesses. The testatrix died on 31st of August 1993. No legal layer.
Lord, she died issueless, my lord. Paragraph 6 I have mentioned.
1993 without any issue. Only she left behind her nephew, three nephews. Full stop. Out of the three nephews, one is the petitioner before this court,
Kanupatro.
and another two nephews have given the affidavit of consent, stating that they have no objection for grant of probate of the last will and testament. The petitioner has also disclosed and enclosed the death certificate of the attesting witnesses. Accordingly, the petitioner has examined one witness, namely
Somen De.
Somen, S-O-U-M-E-N, Somen Kumar De, being the attesting witness of the last will and testament.
Attending witness.
Attending witness of the last will and testament. In his evidence, he has stated that the testatrix has executed her last will and testament in his presence and in presence of two attesting witnesses, and in his presence, the testatrix has put her LTI or RTI?
LTI.
Put her LTI, and both the attesting witnesses are also signed in his presence. But the testatrix as well as both the attesting witness passed away. As he has identified the will as well as the signature of the attesting witnesses, accordingly, the will is marked as Exhibit A, and the attesting witnesses signature of the attesting witnesses have been marked as Exhibit A by 1 and A by 2. Full stop. This could find that the will is of 1993 and 26th of June 1982, and testatrix died on 31st of August 1993. But the petitioner has filed the present application for grant of probate on 10th of June 2022. The petitioner has explained the delay why the petitioner has not filed the present application immediately after the death of the testatrix. In paragraph 13 of the application, the petitioner stated that the deceased died on 26th of June 1982, but the will was misplaced, and recently the petitioner has got the original will in some old scrapped paper lying in the storeroom of the premises number 22 by 1 Creek Lane, Entirely PS, Muchipara, Kolkata. And after getting the said original will, the petitioner has immediately filed the present application. But the learned counsel for the petitioner perused the original will, death certificate of the testatrix, death certificate of both the attesting witnesses, and the evidence of the attending witness, as well as the explanation made by the petitioner in paragraph 13 of the probate application. 13 of the probate application. Considering the above, this court find that full stop. This court find that the attending witness has categorically stated before this court that the testatrix has executed her last will and testament in his presence and in presence of two attesting witnesses, and both the testatrix as well as attesting witnesses have signed the said will in his presence. Considering the above, this court find that the petitioner has proved the will as entitled to get the probate. This court also find that the petitioner has properly explained the delay why the petitioner has not filed the probate immediately after the death of the testatrix. In view of the above, the petitioner and the department is directed to issue the probate of the last will and testament to the petitioner. Last will and testament of the testatrix Rasana Baladasi on compliance of all formalities. At the time of grant of probate, the copy of the probate will be made part of the probate. Copy of the will be made part of the probate. ऊपर मैंने एक और दे देना. The petitioner has also issued the citations, but none has come forward to raise any objection and to file caveat or affidavit in support of caveat. Accordingly, the department has filed no caveat certificate on 4th of September 2024, certifying that no caveat has been entered for grant of probate. Okay?
Lord, exemption, Lord, from drawing up and completion.
The department is directed not to draw up and complete the order.
Extremely grateful.
Next, PLA disposal.
My lord, 48, I am for the sole executor. My lord,
Yes.
this is uncontested.
Your Lordship, I am appearing for the state of West Bengal.
Huh?
I am appearing for the state of West Bengal, Your Lordship, by way of an order dated 5th October 2023. A service was made upon the state of West Bengal in light of the West Bengal Escheats and Forfeitures Act 2012. Since there are no agnates and cognates of the deceased, my lord, but if the will, most humbly, my lord, if the will is proven in solemn form, then the provisions of this act would not be attracted, Your Lordship.
Correct. Yes.
Yes, my lord. There has no legal error, my lord. The sole executor is the only, my lord. He is the.
Who is he?
Yes, my lord. Kindly see the will, my lord. Page number 14. Page number 15, my lord. The testator's father's brother's son.
Where it is?
My lord.
Inner page number?
Page number 15, my lord.
It's not.
The will.
There's no pagination. What is the inner page of the will?
Second page of the will, my lord.
Paragraph?
Paragraph, last paragraph. 5, line 5, my lord. Line number 5, my lord. Kindly see, my lord.
I direct that after my death, my brother Ashok Kumar Ganguly will get all immovable properties and would enjoy the. My brother?
My father's brother's son.
I direct. Where you are getting?
My lord.
I direct. Kindly get the last paragraph. Kindly
I
read
direct that after my death, my brother, Sri Ashok Kumar Ganguly, would get all movable and immovable properties and should enjoy and possess those for whole life, even with the right to transfer any part thereof according to his wishes, and after his death, whatever would remain would devolve my father's brother's son's only son, Sri Dibyendu Ganguly, the sole executor.
Father's brother's son. My
Yes,
father's
brother's son.
My father's brother's sons, namely Dibyendu Ganguly. And also direct me after my death, investment of the bank, so account would be Ashok Kumar Ganguly. And where is Ashok Kumar Ganguly?
Ashok Kumar Ganguly has passed away, my lord.
Also
Kindly see the death certificate of the Ashok Kumar Ganguly, page number 13. He was passed away on 26th October 2020.
October 2020. Yes.
2020. He passed away.
So now what you prayed for?
Grant of probate.
What can be done?
Grant of probate, my lord. My lord, the paper publication was published, my general citation was affixed, my lord. No KVS certificate will be issued. That's
By which order the court has passed an order states?
Your Lordship, by way of an order dated June 15, 2023.
June
15th, my lord, and 5th October. These two orders, Your Lordship.
My lord, also 18th May also, my lord.
5th October?
5th October, Your Lordship. Second last paragraph. Let a copy of this application be served on the Judicial Secretary, Government of West Bengal, in view of the provisions of Escheats and Forfeitures Act 2012 and on Administrators General in view of the provisions of Administrator General's Act.
My lord, as per my knowledge, my lord, the testator has no legal heir. That's why the court directed to that order, my lord.
Yes. So what is your instruction?
My lord, I have sought for instructions, my lord. The instructions are that if the will is proven in solemn form, my lord, then since there are no agnates and cognates, but the testator would not be dying intestate, my lord. So in such regard, my lord, the general citation was also affixed, my lord, on the collectorate, and no response has come in that regard.
Correct.
Yes.
So,
my lord, I have sought for instructions, my lord. I have chased the judicial officer as well, my lord. From their end, they are not having any objection, my lord.
So the state is not having any objects. Correct.
Your lord.
You are not file any caveat. So,
my lord, if a short date may be given.
For what?
I have sought for instructions. They have not given any instructions in this regard. This was told
What
to me.
instruction? It is a property. It is a private property. It is not the state property. If it is the property of the state or the leased property, then you have some caveat. How you are having the interest over this?
Indeed, so, Your
Only the court has passed an order for citation. Citation has been issued, and though the court has passed an order to issue notice to the judicial department has been issued.
Your Lord.
If you satisfy this court, this property belongs to the state. Then you have the state is having any interest over the property, then the court can hear you.
My lord. That is not the case.
So what do you want?
My lord, there is no objection from the state, my lord, in this regard.
No caveat certificate has received.
Yes, my lord. No.
Where is the no caveat certificate?
My lord, in the record. Record আছে no caveat.
Yes. State has also not filed anything.
Your lordship.
Where is the will?
My lord, page 14, my lord.
Okay. What is the date of the will, madam?
The date of the will is 6 September 2020, my lord. 6th September 2020, my lord.
These all are the properties.
Yes, my lord.
That's why the court has issued the notice.
Yes, my lord.
It is over 8 crores, your lordship.
My lord, para 6 of this mile application will dated 6 September 2020.
6 September
2020.
Yes. When he died?
My lord, 23rd January 2021, page 12.
January 20. He died on October.
No, no, my lord, 23rd January.
23rd January.
Yes, my lord,
Yes.
2021.
What is the name?
Sharal Kumar Ganguly.
Where is the original death certificate? You are having the original death
No,
certificate.
my lord.
So it is a corrected death certificate. There is overwriting.
No.
Then you have to prove the solemn form. Where is the original death certificate?
My lord, this is kept on the
Have you gone through the death
executed.
certificate?
Yes, my lord.
It is overwriting.
Yes, my lord.
Thorough and Soral.
Yes, my lord.
So how it can be accepted the Xerox copy?
All original copy are examined by
Huh?
the original copy examined by the filing department. That's why.
No.
My lord, kindly directed to me.
Filing department only seen. Now the court has to satisfy with regard to the
Yes, my
document.
lord. Yes, my lord.
And where is the
Yes, my lord.
what is the J1?
My lord, this application is an amendment application. My lord, first one.
That was disposed of. J1 is
Yes,
disposed
yes,
of.
yes,
By
yes.
which
my
order?
lord.
My lord, order dated June 15, 2023.
15 June, my lord.
Okay. So how you can prove the original certificate?
My
Both
lord.
both certificate you are having?
Yes, my lord. This is
Ashok Kumar Ganguly and Saral Kumar Ganguly.
Yes, my lord. This
What
is
about the wife?
uh,
What about the wife of
both
Saral?
are both are bachelor, my lord. Unmarried.
No, this Saral Kumar Ganguly was bachelor.
Yes, my lord.
He was not married.
No,
Where
my
it is mentioned?
My lord. It's mentioned, my lord. My lord, kindly see the order dated 5th October, my lord. First para. It is submitted that the deceased was a bachelor who died leaving behind no
That's why
legal.
where is the government?
My lord, the application, para number 3 in my application, my lord.
Inherited this.
Para number 3.
Para number 3, Saral Kumar Ganguly
Was a
inherited
bachelor,
the
my lord.
property of the will. Father.
He had a brother, namely Ashok Kumar Ganguly,
Okay.
who was also a bachelor.
Okay, bring the original.
Yes, my lord.
So and so appearing for the petitioner. So and so appearing for the state of West Bengal. Full stop. The petitioner has filed the present application for grant of probate. At the time of hearing, it is found that the petitioner has not brought or not disclosed the original death certificate of Saral Kumar Ganguly as well as Ashok Kumar Ganguly.
Yes, my lord.
According counsel for the petition, press for time to production of the original death certificate of both the deceased. In view of the submission made by the how much? 1 week.
My lord, 4 weeks, my lord.
Where they are
3
res-
weeks.
where they are
2
residing?
weeks, 2 weeks, my lord, 2 weeks. Only 2 weeks, my lord.
The case is adjourned. Let the matter appear on 21st of April. 21st April.
Keep replies, my lord.
Yes, Manoj, it has come at my instance, Manoj. This is an application by the one of the legal heirs of the executor who died during pendency of the will, the probate petition, Manoj. I have taken out an earlier application being GA number 1 that has been disposed of by your lordship. Pursuant thereto, the amendment was intended to be carried out by the department, but that was not carried out in time. That is why this GA2 has been taken out by.
What is the prayer?
Prayer that is prayer. I am seeking prayer B to E of the summons, Malad. Recording the death of the executor.
No, what earlier what was the amendment this court has allowed?
The lordship will kindly come to page 37 being annexary.
37.
Page 37. Earlier order of your
application praying for recording the death of the sole executor who was filed the PH and grant of probate. Consequently, the surrender sole executor died on 8/9 beyond me. Yes, convert. Recording of the death and the conversion.
Yes, ma'am. It has not been acted upon.
Why?
Well, because of during the course of the scrutiny, the department had pointed out certain further clarification is needed.
What?
But that is the reason some portion
clarification
in regard to lords will find page 12. The modalities has not been done in accordance with their suggestion, and some portions there are it is to be converted into letters of administration. Some portion has been left out in that proposed amendment portion. So I am taken out in view of there was a time was there for complete the process by fortnight. That has not been done in the time specified by your lordship, and that is why the second application has been taken out being GA before your lordship now.
So what will happen to the first order?
First order, my lord, that has not been carried out.
So what will happen? The order will remain in the file.
Yes, that will be there. So I am taking out this application.
This application you have taken a further amendment.
No. That the amendment, the nature of amendment are same. In the meantime, lordship will kindly come to the. In the meantime, there was a instruction by my client to taken out an supplementary affidavit. To that supplementary affidavit was intended to be filed by before your lordship, but on the last order, when that was placed before your lordship recorded on the last occasion, this was the observation your lordship as recorded by your lordship's order dated. This is not the last order. Kindly allow me to use that last order.
Whether this is a court or is a lecture room?
No. I'm tendering apology for this, my lord. This is an application by the one of the heirs of the executor for recording the death of his father, being the executor of the sole executor of the last will. And my lord, the recording their names, other legal heirs' names should be recorded, and these particular probate petition to be converted into letters of administration and re-verify and re-apply.
That is already granted. By kindly come to the last order.
That has not been complied with.
That's why kindly come to the page 37. The counsel for the application submission death of so be recorded. Considering submission prayer A to E of the master summons is allowed for recording the death and converting into the probate application to the letters of administration.
Given for fortnight.
Huh?
Time has been given to carry out that amendment within fortnight.
Correct.
That has not been done. That is why this application has been taken up.
This application for extension of time?
Yes, my lord.
No, you have prayed, kindly come to the master summon.
No, I have stated, my lord, in the paragraph. Lords will kindly come to paragraph 15.
Sir, you come
15.
to the master summon.
Yes, prayer is the
What is the
identical
prayer?
The identical prayer is there. But the petition I have stated that I could not carry out the amendment as specified by your lordship's last order. That is why this application has been taken. Paragraph 19, my lord.
So you mean to say in terms of the earlier order passed by this court,
Yes,
the amendment which you have proposed, that is not
carried out.
Yes.
That
correct?
Yes.
So now you wanted to carry it out, but you wanted some addition correction is
No,
also to be-
addition, no, not in that way. Only name has some portion. The only letters of admission is to be inserted, and we left it.
ये पहले का GA का है
Earlier theater देखो.
master summon
One.
recording the data census
ये one. খুলে দিয়েছে কোথায় দিয়ে one খুলে দিয়েছে ওখানে করে দিয়েছে. What was the nature of amendment? Lord, on the last GA, my lords, you will find page 19. The grant of probate, it has been written earlier. That was there. Letters of administration has not been marked. In this type of silly mistakes was committed by the learned advocate during the scrutiny time, my lord. That is the reason I am before your lordship. In this process, my lord, the amendment could not be carried out.
so appearing for the petitioner. The petitioner has filed the present application being GA2 of 2025, praying for carry out the order passed by this court in GA number 1 of 2025, dated 16 January 2025, wherein this court has allowed the petitioner to allowed the petition in terms of prayer A to E of the master summon of GA1 of 2025. Counsel for the petition submitted in terms of the order passed by this court when the petitioner was supposed to carry out the amendment, the department has pointed out that the petitioner has not filed the proposed amendment in accordance with the order passed by this court dated 16 January 2025. Accordingly, the petitioner intend to file a fresh affidavit proposed amendment in place of the earlier proposed amendment which was enclosed in GA1 of 2025. That is the thing.
Absolutely. Sorry.
Considering the above, this court find that considering the above, the department is directed to accept the proposed amendment as disclosed by the petitioner in Annexure B of the present B of the present application instead of the proposed amendment enclosed by the petitioner in Annexure C of GA1.
Earlier GA1. Yes.
22. GA2 of disposed.
Order in terms of pair A and A to E. of this part.
That already order is there.
Time is fortnight, my lord.
The petitioner is directed to carry out this. The department is directed to carry out the amendment within 3 weeks from date.
Good.
Simple thing. You are
I'm
going
making-
here and
making it
there, here and
complicated.
there.
I'm making it complicated. I'm tendering apology.
You have wasted the time of 15 minutes.
Sorry.
My lord, I think so.
Yes.
My lord, it is, my lord, will dated, my lord, 26th March, my lord, 2008. My lord will get
2008.
What
is the name of the testator?
Yes, my lord. The name of the testator is Bimalananda Haldar. My lord will get with the will in page 11.
Where is the name of the testator in the will? This will is the so.
Yes. Signature is there.
Where is the name of the testator in the will?
Signature.
Today is the day. I don't.
Signature.
Signature is there.
17. In and page 17 top. I Bimalananda Haldar.
Bimalananda Haldar. Yes. Where is the name of the executor?
My lord, page 17, my lord.
Page 17.
First witness.
No, name of the executor.
My lord will find in page, my lord.
I hereby appoint
15,
Biswarup
15,
Haldar,
15.
executor of this will.
Yes.
Okay. Altogether, how many witnesses? 3.
My lord, see.
3 attesting witnesses. When he died?
The testator died, my lord, 30th January 2013, my lord. Page 10, my lord.
January 2013. And you filed the application on?
My lord, 2024, para 2.
Okay. How many legal heirs?
My lord, three sons, my lord, has given consent, and one is the executor.
3 sons.
3 sons, 2 sons given consent.
So one is a son.
One is the executor. One son is
Consent. Where is the attesting witness?
My lord, it is the, my lord, first attesting witness.
Biswarup.
No, my lord, Rabindranath Mundok. It is dated, my lord, 11th of September. Attesting witness.
Yes. That's all.
That's
Sense appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 26th March 2008 of the testator Bimala Bimala Nanda Haldar. Counsel for the petition submitted. The testator has executed his last will and testament in presence of 3 attesting witnesses while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will and testament. The testator died on 30 January 2013, leaving behind 3 sons.
Widow is predeceased.
Huh?
Widow is predeceased.
3 sons, out of which one son is the petitioner before this court. The wife of the testator was predeceased to the testator who died on
15 January
2006. Counsel for the petition submitted that all the 2 legal heirs have given their affidavit of consent stating that they have no objection for grant of probate to the petitioner. Out of 3 attesting witnesses, one of the attesting witnesses, namely Ravindra Modak, has filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of other attesting witnesses while possessing good health and fit state of mind by appointing the petitioner as sole executor. Full stop. This could full stop. Counsel for the petition submitted the petitioner has proved the will and entitled to get the probate. Consider the submission made by the counsel for the petitioner, peruse the original will, death certificate of the testator, affidavit of consent of both the legal heirs, and affidavit of the attesting witness. This could find that the will is of 2008 and the testator died on 2013, but the petitioner has filed the present application only in the month of September 2024. Full stop. Counsel for the petitioner has explained the delay for not filing of the present application immediately after the death of the testator In paragraph
2 bottom, my lord.
Huh?
From paragraph 2,
Hmm.
para 2, from the middle portion, be it mentioned here that.
इतना क्या बोला? In paragraph 2, stating the fact that the will could not found, and after the death of the testator, the will could not found. Only in the first week of July 2024, the petitioner got the said will, and accordingly, the petitioner has filed the present application. Considering the above, this court find that the petitioner has proved the will and also justify and also given the proper explanation as to why the petitioner has not filed the application immediately after the death of the testator. Considering the above, this court find that the petitioner has proved the will and entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 26th of March 2008 on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. The department directed not to draw and complete the order. PLA number 7 disposed of.
Grateful.
Yes. Next.
So there is an application for letters of administration of the estate of the deceased with a copy of will. It is a will dated 10/9/1971.
1971.
1971. The original executor of the will expired on 2015. The testator had one son and one daughter. The son was the executor, and now the son's son, Rakesh Tandon, is the applicant. He has filed.
Why son is the applicant?
Because the son who was the executor has died in 29/9/2015.
Okay.
The original executor. That's why I am filing for letters of administration.
Okay.
Now, all the no objections of the sons and daughters of the original testator all of the grandsons and granddaughters of the original testator has been submitted, including the daughter of his daughter.
Where is the will?
The will is in page 16, Lordship.
Page 16.
Lordship.
This is a 72 document.
71 document, Lordship.
71 document.
Yes, Lordship. The explanation is given in page
71 document is so fresh.
Lordship.
Even you kept in the bank locker also, it cannot be. This is a will.
Lordship.
Where is the name of the executor?
Name of the
Govardhan Nath Tandon.
Govardhan Nath Tandon.
What is the date of the will?
Date of the will is 10/9/1971.
72. 10/9? Which case?
Item 50.
PLA 376.
PLA 376, Lordship.
Yes. Of Dwarkanath Khetri.
Dwarkanath Khetri.
Yes. Then, which page you are? Where is the will? Which page you are
Page
referring
16,
the will?
Lordship.
Huh?
Page 16.
Page 16, Dwarkanath. How you got the date?
21st day of March 1972, Lordship.
Where you got the date? Earlier date?
Page 18, I think.
Where you got the date? Earlier you mentioned the 71.
In para 6, I think it has been mistaken.
Paragraph?
Para 6, page 4.
Para 6.
I think it has been mistaken. 10 September 1997.
Para 6, page 4.
Page 4.
10 September. No.
It has been mistaken.
No. Which application you are referring?
The main.
Para 6, page 4. What is the read the paragraph?
Your petitioner states that your petitioner ascertained from the said will of the deceased dated 10 September 1971 that there were two attesting witnesses who has put their signature.
No. Only this case, see this application.
I think they have given me some wrong document, Lordship, the AOR. I shall the 21st.
Inspect the document first, then come you.
The 21st day of March.
Correct. As per the prayer made by the counsel for the petition, the case is adjourned. Petition is given liberty to inspect the record of the present case. Let the matter appear on 7th April.
Letters of administration.
Which one?
Just the next matter, my lord, 52.
Give the 52.
Only letters of administration without will, my lord. The death certificate is at page 8, died in Doha.
Without will?
Without will, my lord. Without will.
Where is the death certificate?
Everyone has given consent.
Where is the death certificate?
At page 8, my lord. Died on 13 December 2022.
Qatar.
Qatar, Doha. All properties inside, my lord. All properties inside.
Where is the date? 13th December 2022.
13 December, so it's written reverse, man. 22/12/13. Shomo Bose. In first paragraph, I've written the date 13th day of December 2020.
Correct.
Paragraph
How
3,
many legal heirs?
my lord, 1, 2, 3, 4 legal heirs, my lord. The second legal.
Who is the petitioner?
Second one is the petitioner.
Second one is the petitioner.
Yes.
Aniruddha Bose.
And all the other legal heirs have filed their consent.
Consent affidavit Mallika.
Mallika Bose, Gaurav Basu, Siddhartha Basu.
Mallika, Gaurav,
and Siddhartha Basu.
Where is the affidavit of?
Yes, my lord, affidavit of, in affidavit, my lord, it's around 14 crores. The lordship comes to pass internal page 5 of the affidavit. The total comes to 14 crores 74
14 crore
lakhs.
74 lakhs.
Yes. Praying for 2 sureties, my lord.
So suffering for the petitioner. The petitioner has filed the present application for grant of letters of administration of the properties and credits of the deceased
Shomo Bose.
Somo, S-O-U-M-O, Somo Bose, who died on
13 December 2022.
13th of December 2022, leaving behind his wife, his mother, wife, and 2 sons. The wife is the petitioner before this court. Wife is the petitioner before the court, and other 3 legal heirs, that is the mother and both sons, have filed their affidavit of consent stating that they have no objection for grant of letters of administration to the petitioner to the estate of the deceased. Police. Consider the submission made by the counsel for the petitioner. Peruse the application from a death certificate of the testator, affidavit of deceased, and the affidavit of the legal heirs. This court finds that the legal heirs have categorically stated that they have no objection for grant of letters of administration to the petitioner to the estate of the deceased. Consider the submission. This court finds that there is no impediment for grant of letters of administration to the petitioner without the will throughout the state of West Bengal upon furnishing the personal bond of rupees.
It will be, my lord, 14 lakhs.
Furnishing bond of rupees 15 lakhs. 15 lakhs with 2 sureties. Personal bond of rupees 14 lakh with 2 sureties. The PLA number is disposed of.
I'm grateful, my lord.
My lord,
Yes.
may I start? My lord, my junior, Lani junior, my lord, on the last occasion, my lord had shown, my lord, he had given, my lord, certain ideas about, my lord, the suspicious circumstances appearing from the attendance circumstances, my lord, pleaded and proved, sought to be proved in this proceeding. Number one. My lord, according to his understanding of the situation that was narrated to my lord, that incorrect recital, it also, my lord, gives rise to the occasion that there is a suspicious circumstances. My lord, if your lordship takes pain, my lord, to tally the signature of my lord the Kiranwala in two different documents. One is of my lord in the will, Kiranwala alias, that is Jade, possibly he has submitted, my lord. And he has also possibly relied on an authority, my lord, propounded by the Honorable Supreme Court, 2009 3 SCC 687, possibly, my lord. My learned junior, my lord, your lordship was kind enough to take note of this judgment, my lord. So, my lord.
2009
Yes.
and 2020 and
Yes,
2020.
yes. Now, my lord, the signature, my lord, that has been sought to be proved of one of the witnesses, my lord, both of witnesses, admittedly, my lord, they have gone to the glory, they have expired. Now, today, my lord, relying on the, my lord, the handwriting expert, my lord, they said, my lord, this. Now, this is based on, my lord, the interpretation of these three sections or four sections. They relied on section 69 of the Indian Succession Act, when no such evidence is evidence act, my lord. So today, my lord, I will rely on, my lord, first Indian Succession Act 63 and 68. Right? Huh? I'm sorry, my lord, I'm taking 1 minute time. 63 টা বার কর না Indian Succession. My lord, according to my humble understanding, I wish to take my lord's kind attention, my lord, to section 63 of the Indian Succession Act. May I hand up the? I'm deeply obliged, my lord.
63
Yes, my lord.
Indian Hague.
Indian Succession Act, my lord, 1925.
Section
Section 63.
63, yes.
63. Execution of unprivileged ways.
Yes.
Every testator not being a soldier employed in an expedition or engaged in actual warfare and such shall execute his will according to the following rules. The testator shall sign or shall affix his mark to the will, or it shall be signed by the some other persons in his presence and by his direction. The signature or mark of the testator or the signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. The will shall be attested by two or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by the direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark, or of signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witnesses be present at the same time, and no particular form of attestation shall be necessary. So the last two parts, but it shall, it is mandatory, not mandatory, directory. But the other form of compliance, my lord, is possibly mandatory. And my lord, section 69, which my learned senior friend, my lord, on the last occasion read for my lord, in order to appraise that evidence act,
That
my
is
lord.
evidence.
Evidence act, my lord. I'm sorry, my lord.
Give the evidence.
Yes. It's 1668 তো দেখে নিচ্ছি কিছু আমি কেন বলেছিলাম Yes. 69, my lord. it says, my lord, that proof where no attesting witness found, if no such attesting witness can be found, or if the document purports to have been executed in the United Kingdom, it must be proved that the attestation of one attesting witness, at least in his handwriting, that the signature of the person executing the document is in the handwriting of the person. My lord, section 68, my lord, 68 of the Evidence Act says, if a document is required by law to be attested, it shall not be used as an evidence unless one attesting witness at least has been called for the purpose of proving its execution, if there be an attesting witness alive, yes, and subject to the process of the court and capable of giving evidence. Correct. According to my learned senior friend, 68 has been explained. That is in not derogation of, but in addition to, my lord, 68, 60, 69. My lord, with the deepest humility and respect, my lord, I submit, my lord, that without disturbing, my lord, the fulcrum of this or the edifice of these two sections of the Evidence Act, I respectfully submit, my lord, that 63 of the Indian Succession Act, more particularly the mandatory part of clause 6 of section 63, my lord, this cannot be given go by. My lord, this is in addition to, but this Indian Succession Act, my lord, it is a substantive law, and such law, this mandatory part, my lord, cannot be waived by only in absence of the two witnesses. More particularly, my lord, this has to be seen on the diligence of a man, my lord, who seeks letters of administration after 20 years from the date of the death of the testatrix, my lord. Why I tell your lordship, my lord? So, this unexplained delay also, my lord, causes, my lord, suspicious circumstances.
No, this with regard to the delay, it's okay. That is different thing. With regard to attestation of the will by the two witnesses in terms of section 63, it is the law under 63. It has to be proved by two witnesses. It has to be executed in presence of two witnesses. Correct, and the propounder has to prove the will in terms of the 63 by examining the attesting witnesses. Now, Mr. Dutt has stated that these two attesting witnesses were not available, so that's why he has taken the recourse of 69 of the.
Right, I understand, Miller. That is why I said that 68 and 69 is not in conflict. Yes, that is my. I agree with the proposition of law. I cannot say the legislature in is, but I say that this 63, the in addition to, but not in derogation, it does not, Miller, destroy the other premise clause C. Yes, so, Miller, these conditions are necessary and required to be complied with. Now, Miller, I wish to rely on a judgment reported in 2023 SCC Online Supreme Court 1488. Yes. Miller, this is a judgment, Miller, which, Miller, explains, Miller, subject to correction, Miller, 1999, paragraph 19. May I read for my lord? In turn, section 68 and 69 of the Indian Evidence Act, for brevity read as under, Miller, they narrated the section. Then tried to state mere registration of a will does not attach to it a stamp of validity, and it must still be proved in terms of the above legal mandate. Janaki Narayan word such and such. This court held that the requirement in clauses A, B, C of section 63 have to be complied with to prove a will, and the most important point is that the will has to be attested by two or more witnesses, and each of these witnesses must have seen the testator sign or affix his marks of the will, or must have seen some other person sign the will in the presence of and by the direction of the testator, or must have received from the testator a personal acknowledgement of his signature or mark, or the signature or mark of such other person, and each of the witnesses has to sign the will in the presence of the testator. It was further held that a person propounding a will has got to prove that it was duly and validly executed, and that cannot be done by simply proving that the signature on the will was that of testator, as the propounder must also prove that the attestation were made properly as required by section 63. Correct. So that is my understanding, Miller, supported by Honorable Supreme Court. Yes. So this mandatory provision cannot be waived. So, Miller, today, this delay of 21 years, Miller, of from the date of the testatrix, By this time, my lord, all the parties alleged to be aware of the will died, including the executor, because who was already in possession of the will, and the two attesting witness, Mihir Kumar Datta and Mr. Shitesh Sana, the first beneficiary, namely late Diptilal Banerjee. Now, my lord, surprisingly, or possibly incidentally or accidentally, this letter of administration was filed immediately after the death took place, so far as Dr. Mihir Kumar Datta is concerned.
Yes.
Now, my lord, according to our understanding from the attendance circumstances, my lord, the conduct, my lord, suggests in no uncertain terms, subject to what my learned senior friend will say and my lord will hold, that this is a deliberate delay, my lord, which can be attributable to the applicant, because, my lord, these 21 years, my lord, possibly invites the court to cause an inquiry under Section 3 of the Limitation Act. That is my understanding. Even if no parties in the proceeding have raised this question of limitation. Now, my lord, I request your lordship to go to, my lord, question number 38 to 40 of PW2. 38 to 40 টা বার কর। হ্যাঁ কি করে বল PW2 my lord, I'm sorry.
PW2 কোথায়?
This one. My lord has got it. Deeply obliged. 38 my lord.
Yes.
My lord, where did you find this letter from after the death of my mother sometime in 2014? When 2014? 2004.
2004.
My lord, corrected, my lord.
Should be 14.
It should be 14 my lord. Hey, दिखाओ ना bro. ये चीज को दिखाओ, 40 वो जैसा बोल रहा है कि 2004 है। इंद्रजीत
Is this
It should be 14 my lord.
This week you need
40.
14.
question number 40?
14. Actually, they are not charactered in the origin.
Oh. So, my lord, in 40, when did you discover this document? Mother died, my lord. His mother died 14th April 2013. And, my lord, this is also not very reasonable. And to suggest, my lord, that after 1 year from the date of the death of the mother, the only son, my lord, opened the umbrella, my lord, after 1 year.
Yes.
And it is also not possible to conceive, my lord, by a man of ordinary prudence, that if the will was, my lord, was executed in the year 83, if it was, my lord, in the Elmira of his mother, deceased mother, my lord, from 83 to 2014,
yes,
my lord, nobody in the family, 3 persons, my lord, were there, and my lord, nobody had the occasion to go through it. It is not like a big room; it's a one almari, my lord, almira. So, my lord, it is also not very reasonable to suggest, my lord, these narratives. I would suggest, my lord, this is a kind of a fairy tales, my lord. Now, my lord, 42. Where was this letter prepared? In the office of my father, and she had signed it in front of me. I'm sorry, my lord. Has the original letter received by the corporation? Yes. Why I am telling your lordship, my lord, this original letter, my lord, this after the date, after, my lord, in the year 2002, my learned senior friend's client, my lord, got his name mutated along with Priolal, my lord, in respect of the property. Correct. So, my lord, presumption is, my lord, he was well aware of, my lord, each and every corner of the house and the property, description of the property, everything about the property, because corporation, Kolkata municipal, out of nothing, my lord, could not, my lord, get his name mutated without any document.
Correct.
So, my lord, presumption of fact may be, my lord, that is my respectful submission, understanding that this gentleman was armed with this knowledge that there was an existence of the will. So, from 2002 to 2014, there is also, my lord, 12 years gap. Now, my lord, if your lordship wants me, my lord, to show the document, my lord, for the sake of, my lord, the eradication of any cloud, my lord, if it shrouded the minds of the judge, but I would like to take my lord's kind attention to 13th October 2015's document, second judge's yes. This RTI application, it reveals this RTI application, the answer page this exhibit 1.
Exhibit 1, 1310.
Yeah, 13. I'm deeply obliged, my lord. Name of the recorded owner, my lord, Sri Priyolal Banerjee and Srimati Kiranwala Devi. And then a mutation case was, my lord, initiated, possibly at the instance of my learned senior friend's client 110/2002. His name is found to be recorded as a recorded owner against the subject. So, my lord, he had certain documents. My lord, if I take this, my lord, that this gentleman was not armed with the will, then, my lord, the Kiranwala's legal successor at that point of time, when the will was admittedly not placed for probate, neither for the letter of administration, even then, my lord, all the legal owners, in absence of any will, my lord, all legal owners, my lord, name should have been recorded in the mutation, because corporation is not a title deciding authority. So corporation corporation should have asked, my lord, who are the legal heirs? Possibly there was an affidavit submitted by my learned senior friend's client. But, my lord, eventually it suggests, my lord, that the name of, my lord, Priyolal, the eldest son of Kiranwala, and, my lord, Indrajit Mukherjee, my learned senior friend's client, my lord, his name was recorded.
Mutation being mutation number
both name deleted, Indrajit names were incorporated. Only one. Priyolal and Kiranwala was removed by virtue of the case initiated by the Kolkata Municipal Corporation. Based on his application, Priyolal and Kiranwala removed. He survives only.
So how the Priyolal was removed?
Yes, we don't know. And no answer, my lord, was forthcoming. So, my lord, whenever there is a mystery, my lord, it leads to the path of suspicion. Now, this suspicion, my lord, is enough, my lord, to, my lord, question the propriety of a will, my lord. So, my lord, the delay coupled with such mystery, my lord, possibly subject to what my lord say, my lord, will strengthen our case. Now, my lord, kindly comes to, my lord, question number 77 to 81. Oh, sorry, my lord. 46, my lord. 46, 47. Before I go to this, my lord. TW2. No. Did your parents, may I read for my lord? Deepak Banerjee, alias Diptilal Banerjee and Ranu Banerjee, prior to their death, apply for letter of administration in respect of this will? No. To the best of my knowledge, they had not applied. Should be any letter of administration, because the original will was discovered in the Almira sometime in May 2014. Is this the same place where you just now said you discovered the letter of the administration and some documents? Yes, all the original documents were in the same Almira. So without, my lord, making a tiring repetition, my lord, I would go to, my lord, I will go to, my lord, question number, my lord, 77 to 81. What could be 77 to 81?
Yes.
77. Where did you have the occasion? When did you have the occasion to mutate this property in your name? Sometimes after my mother expired in April 13. I was under serious depression. I was unwell after the death of my grandmother it should be, and when my wife was organizing her room in which she lived, she found a bunch of keys in my mother's vanity bag and opened wooden almirah to organize it. While organizing her personal effects, she found a photocopy of the will, not the original. Then, what did you do? I was having a lot of problems at that time. I was also having some issues with the company and also having issues with taxes. And since I was paying all the corporation taxes, I approached Kolkata Municipal Corporation to mutate the property in my name. My lord, one submission in this regard, my lord has seen, my lord, that a gentleman in 2002 was so mentally active and alert, my lord, that immediately, my lord, he got his name mutated. Priolal and Kiranbala, my lord, their names were removed. Such gentleman, my lord, was so oblivious, so far as, my lord, the material possession of the other things pertaining to the property, my lord. And after, my lord, 12 years, and before that, my lord, because the Kiranbala, at the age of 88, my lord, she was certainly feeble, and the handwriting suggests, my lord, that she was not in a very good state. Be that as it may, my lord, this gentleman, my lord, Mr. Mukherjee, with deepest respect, my lord, took 12 years time to understand, my lord, and he's lied on the dog the key, because he said, and he said that some issues I was paying. I approached Kolkata Municipal Corporation to mutate the property in my name. This deposition was made, my lord, after 2014. But the document shows 13 October 2015 that this was done way back in 2002, and his name was mutated. He is the beneficiary of the will. So in 13 years, when he made a statement on oath, my lord, in the highest court of the state, he said, my lord, that he approached the Kolkata Municipal Corporation to mutate the property in my name. Why a person, my lord, should go to the...
Answer to the 78 is contrary to the Exhibit 1.
Yes.
That is
yes, and my lord, when documentary evidence will always supersede, my lord, the oral evidence, prevail over it, my lord. So, my lord, this deposition will show, my lord, the state of mind of a, my lord, witness, my lord, who, according to me, my lord, made incorrect statement, my lord, and such conscious omission, my lord, should be, my lord, discarded. Now, my lord, kindly comes to, my lord, question.
Yes.
Hey, it is gone now. Oh.
Next.
Next, 186, my lord.
186.
Yes, my lord, deeply obliged. My lord has got it.
Yes.
Oh, I'm sorry, my lord. Just a minute, my lord. 174. I'm sorry, my lord. It should be, my lord, 174. I have committed a mistake, my lord.
Yes.
Yes. Why did Madhusudan Parida live in the house? His grandfather also used to live in the house. He also lived in the house. He used to do some household work when he was in the house. Is it your evidence that the father of Madhusudan Parida worked for your family? He said no. Then what household work did the father of Madhusudan Parida do? Father of the Madhusudan Parida never lived in the house. His grandfather used to live in the house. Why did the grandfather of Madhusudan Parida live in the house? I cannot say. My grandmother provided a space for him to live there. What household work would the grandfather of Madhusudan Parida do? I cannot say. Did you see grandfather of Madhusudan Parida? Yes, I did. At that point of time, did you see him doing in the household work? I cannot remember clearly, but once in a while, he used to work in the garden. Can I take it that the grandfather of Madhusudan Parida was the gardener at our house? Huh? Your house. He was not appointed a gardener, but at his will and wishes he used to tend to the garden at times. What do you mean by the words appointed gardener? Appointed means he was not paid, if I remember correctly, any money for being the gardener. Millard, his selective amnesia with regard to Millard, the certain events which he cannot remember, and he could remember only Millard that there no money was paid to this Millard. Millard, this such Millard, this is also Millard created suspicious circumstances. How did you come to know that he was not paid? As I mentioned, that is from my recollection. Millard, this is also a conscious choice of words, which Millard lead to the path of confusion for the simple reason that he was well aware with regard to the appointment of the father, the son, and the grandson and the grandfather, but he selectively Millard forgot to remember that his appointment, the factum of appointment was also clearly remembered, but he cannot remember whether any money was paid or not.
So that's why we call the intelligent witness.
Millard, It is sometimes called, my lord, that witness is the guest of the court. So, but, my lord, the problem is, my lord, that one should be aware, my lord, that what is the kind of statement, my lord, we make in the highest court. My lord, every action must be coupled with responsibility. When it is especially, my lord, pertaining to a curial combat. Yes, because we have some responsibility as a citizen. And as an advocate also, my lord, we have to make some responsible statement. Otherwise, my lord, the assistance would not be meaningful, my lord. Be that as it may, my lord, we are also human being. We are prone to error. But however, my lord, we say, it is my perception that such selective omission, my lord, will not take us anywhere. Rather, my lord, it destroys the entire edifice of, my lord, his deposition. Now, my lord, I would take, my lord, to question number 186. Yes. What did your mother do after Madhusudan Parida told her that your grandmother has allegedly executed a will in his presence? My mother was very ill before she died, and she mentioned that the original will was handed over to my parents, Baba and Ma, father and mother, by Shejo Jetu, that is the third elder parental uncle, and also mentioned that Madhusudan Parida would have seen some documents being signed by the advocates and by my grandfather. Now, my lord, grandmother. Now, my lord, then you said your mother was ill, very ill. Just a minute, sorry. What would be the age of Madhusudan Parida? That must be in my submission in the documents. I cannot recollect. What would be his age now? I do not remember right now. What would be your assumption as to his age? He should be 52 to 53 odd years. Can you show any document? Sorry, to establish these dates? The document establishing his age have been submitted in the court already. You said your mother was very ill. What ailment she was suffering from? Her main issue was high blood sugar, and then she had a stroke, which was the cause of her death. When did your parents receive the will from your Shejo Jetu? I would not be exactly aware of the dates. Since your father died on 1/9/2004, 5, would you agree it must be before that date? Yes. Was the original will given to your parents or the photocopy? As my mother mentioned, it was original will. So, Millard, the story of Millard, or the narratives of Millard, discovery of the will, Millard, from the Almira 2014 Millard, it also, Millard, it stands far away from the reality, in a way. Yes. Now, Millard, this deposition has to be subject to correction, Millard, adjudged, Millard, in the context of paragraph 8 of Millard, the plaint or application, Millard. Application task?
Yes.
Yes, I am deeply obliged, Millard. May I read for my lord? That the will is proved by the affidavit of Sri Madhusudan Parida, son of late Sudarshan Parida of number 2 Tangra Second Lane, Police Station Tangra, and also at such and such, Kendrapara, the attending witnesses of the said will, and the last testament dated 18 July 1986, as the named attending witness Mihir Kumar Datta, Doctor, and Sri Sitesh Sinha, advocate, in the last said will, both have already died, and there are none to adduce evidence except the said attending witness, which is filed herewith by his declaration signed at the foot of the petition.
Yes.
And Millard, he was never called as a witness, Millard, to prove such thing.
Farida has not come.
No. Millard, this was not by accident but by design, because further accident might have occurred, Millard. Now, Millard, I will take my lord's kind attention to question number. All right, Millard, then. So, Millard, so far as delay part is concerned, Millard, this is my understanding, and in one witness, only another Millard part. I'm taking Millard only 2 minutes time. I'm sorry, Millard. I apologize.
Question number 2.
69 ও মুসুরি থেকে কলকাতায় আসতো, এটা 69 এ দেখাচ্ছে এখানে, কারেক্টেড করতে দেখতে বারবার করে yes, a line of questioning that he used to evidence na cross evidence I used to cross এ আছে কত রে কত নম্বর এটা 69 কত 99 Millard, I would take Millard's kind attention to question number 99 PW2 Millard. So 90 no 97. I read start from 97. May I read, Millard? Where have you done your schooling from? I have done my schooling from Calcutta Boys and thereafter from Mother International School in Delhi and from class 6 onwards in Mussoorie Modern School. In 1986, where were you? I mean, in which school? I was in Mussoorie Modern School, Mussoorie. How often would you come from Mussoorie to Kolkata during your school days? I would often come during my vacation. By vacation, what do you mean? We used to have summer vacation and winter vacation. Will I be correct if I say that summer vacation was given in the month of May or June? I do not exactly remember the month. In the 1993, where were you? In 1993, I was studying in Kolkata. You have admitted that your grandmother Kiranbala had 4 sons, 4 daughters. I am correct? Am I correct? Yes, that is so. You would agree that there had been no will. The 4 sons and 4 daughters would be the joint owners of the estate of Kiranbala Devi. I do not have much legal knowledge. I cannot comment on details. You had in your answer in question number 88 that on the date when will was executed, were you and someone of the house present at the time? This time in the house, I live in a very big house. The house is surrounded by the garden. My father's office was also there and factory sheds. I do not have much assumption as to who comes and goes. I am asking you whether on the date of execution, you remember the date you were in the house which you have deposed before the Honorable Court? Do you remember? As I said, I have a very big house. I cannot say who were present, who were coming and going. It is not possible for me to say. So I would mean to say that it will be beyond my knowledge. I think someone would be visiting my grandfather. On what basis do you say you were in the house? I do not remember. Maybe I was in the house or may not be. Millard, this is a kind of attempt, Millard, to fill up the lacuna, Millard, in the first Millard. Millard, this is, he said, in question number 88, he said, Millard, he was there. Yes. So, Millard, such contradiction, Millard, sometimes we said, Millard, that the contradiction can be reconciled, but sometimes, and Millard, in other cases, Millard, if find it is very difficult to reconcile. So, Millard, this is devastating, destructive.
Yes.
Yes. So, Millard, so in a way, the gentleman who deposed as PW2, Millard, I can, not with conviction, but with some certain certainty, Millard, I can vouch with deepest humility that this gentleman is well aware of the existence of the will, Millard, since 1993, Millard, 1996. And Millard, if one reads the entire deposition, then one will find that this contradiction, Millard, is sometimes is a reflection to an attempt on the part of the PW2 to fill up the lacuna. So, Millard, this is not a credible witness. Okay. So, Millard, why this has been attempted to make, my lord, this has been done. My lord, my respectful submission from the understanding of the attendant circumstances that your narratives, my lord, is only in order to cover up the inordinate delay. Otherwise, my lord, he could not have taken so much of pain, my lord, when admittedly, my lord, this attempt of 2014 application is absolutely, my lord, contrary to his, my lord, passionate attempt to get his name mutated. So, my lord, his state of mind, he is not a man, my lord, who, my lord, is averse to, my lord, the material possession or, my lord, this property, all right, because he was very much well within. So, my lord, that is my respectful submission that the delay is required to be explained in a situation where the evidence or the deposition of the witnesses are contradictory to each other, not credible. And in that situation, my lord, the court, by virtue of section 3 of the Limitation Act, my lord, can make a suo motu inquiry. Yes. And limitation, my lord, this is, my lord, reported in 2020 12 SCC 480. Samir Kapoor and another versus paragraph 16.2 টা দেখাচ্ছে 1 থেকে হ্যাঁ Millard, the paragraph 15 subject to correction, Millard, that is my humble understanding of the situation and law, Millard, that section 15 may paragraph 15 of the judgment. Now the next question which may arise for consideration would be whether an application for probate or letter of administration with will, the period of limitation would begin to run from which date. While considering the issue involved, the decision of this court in such and such is required to be referred to and considered. In the said decision, this court considered that the decision of the Bombay High Court in such and such case, as well as the decision of the Madras High Court in S. Krishna such and such, in re, in the said decision, this court referred to and considered para 24 of the decision of the Madras High Court in such and such case, which reads as under. In a proceeding, or in other words, in an application filed for grant of probate or letter of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letter of administration issued by the competent court is a conclusive proof of the legal character throughout the world. An assessment of the relevant provisions of the Succession Act 1925 does not convey a meaning that by proceeding filed for grant of probate or letters of administration, no rights of the applicant are settled or secured in the legal sense. The author of the testament has cast the duty with regard to the administration of his estate, and the applicant for probate or letters of administration only seeks the permission of the court to perform that duty. There is only a seeking of recognition from the court to perform the duty. That duty is only moral and it is not legal. There is no law which compels the applicant to file proceeding for probate of letters of administration. With a view to discharge the moral duty, the applicant seek recognitions from the court to perform the duty. It will be legitimate to conclude that the proceeding filed for grant of probate or letter of administration is not an action in law. Hence, it is very difficult to, and it will not be honored to construe the proceedings for grant of probate or letters of administration as application coming within the meaning of the application under Article 137 of the Limitation Act. This court approved the observation of para such and such Madras High Court. Therefore, insofar as the nature of the petition for grant of probate or letter of administration is concerned, however, this court did not agree with the finding that the application for grant of probate or letters of administration is not covered by Article 137 of the Limitation Act. In the aforesaid decision, this court also considered and referred at SCC, Limitation Act, Article 137 work on it. Decision, court also considered and referred at SCC page 460 para such and such to para 16 of the decision of the Bombay High Court in Vasudev such and such in para 15, which reads as follows. Rejecting Mr. Dalpatri's contention, I summarize my conclusion thus. Under the Limitation Act, no period is advisedly prescribed within which the application for probate letters of administration or succession certificate must be made. The assumption that under Article 137 the right to apply necessary accrues on the date of death of the deceased is unwarranted. Such an application is for court's permission to perform legal duty created by a will for recognition as a testamentary trustees and is a continuous right which can be exercised any time after the death of the deceased as long as the right to do survives and the object of the trust exists or any part of the trust, if created, remains to be executed. The right to apply would accrue within it becomes necessary to apply, which may not necessarily be within 3 years from the date of the deceased death. Delay beyond 3 years after deceased date would arouse suspicion, and greater the delay, the greater would be the suspicion. Such delay must be explained, but cannot be equated with the absolute bar of limitation, and was execution and attestation are proved, suspicion of delay no longer operates. The court did not agree with approve of conclusion B, however, approved conclusion C uh, reproduced herein above. Therefore, considering the law laid down by in such and such, it can be said that in a proceeding or other words, in an application filed for grant of probate or letter of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate and letter of administration issued by the competent court is conclusive proof of the legal character throughout the world that the proceeding filed for grant of probate is not an action in law but is an action in rem as held by this court. An application for grant of probate is for the court's permission to perform a legal duty created by a will for recognition as a testamentary trustee and is a continuous right which can be exercised at any time after the death of the deceased as long as the right to do survives and the object of the trust exists as part of the trust, if created, remains to be executed. Therefore, even if his will is probated by any court mentioned in 228 of the Act, the right to get the letter is a continuous right which can be exercised at any time as long as the right to do survives and the object of the trust exists and such created remains to be exist. Applying the law laid down by this court in the aforesaid decision and the observation made herein above, the submission made of the applicant such and such probate case, the letters of admission on the railway section is barred by law of limitation and cannot be accepted. At this stage, it is required to be noted that even in the plain, it is specifically pleaded that after passing away of the father of the parties in the year 2000, the appellant started intermeddling with properties bequeathed to respondent number 2, which was situated in India, therefore left with no option. He was compelled to apply for letter. Therefore, even as per the pleadings in the application, the cause of action started from the date on which the applicants started intermeddling with the properties bequeathed to respondent number 2 after passing away from the father of the parties in the year 2000. Therefore, in the facts and circumstances, both the learned single and the division bench have rightly refused to reject the application exercise of the power under Order 7 such and such. In the facts and circumstances of the case as observed, however, cannot be said that an application for data admission was clearly barred by law which is required to be rejected in exercise of power under such and such. We are in complete agreement with the view taken by the High Court. In view of the above, the present appeal fails. So, Millard, Article 137. So, Millard, the more the delay, Millard, the more the suspicion. So, Millard, the deposition, the evidence, the record, the plaint, it clearly suggests that he had a knowledge, that he was armed with the knowledge on and from the date of Millard, the execution. And more so, the moment Millard, the Kiranwala passed away, despite Millard, his father was alive, 2005, all witnesses are alive, Millard took the passionate initiative to get his name mutated. So Millard, he is a man who has a burning desire to control the whole family desires, and he has proved himself to do so because despite his parents were alive, he had done so Millard in his own name. So Millard, parent Millard maintained silence. So Millard, this letter also must fail. I'm extremely grateful. Thank you.
Yes.
Your Lordship, would like us to start today, or would you like to give another date for us to deal with the contentions made today also, Your Lordship?
As per your wish, 15 minutes is there.
May I take my Lord's kind leave to?
Yes, you
and give you a blessing. I'm sorry.
Your Lordship, may I just give a small synopsis of all the things that has happened thus far? Just briefly, Your Lordship. Your Lordship, the present suit pertains to grant of letters of administration for the last will and testament of the testatrix dated 18 July 1986. Copy of the will is part of the judge's brief, page number 2 to 10. The will, the testatrix is the grandmother of the propounder herein.
See, there is no dispute with regard to the relation with regard to the property. Only the first question they have raised with regard to the delay.
They have accepted the existence of the will, Your Lordship. There's no
No, they have accepted with regard to accepted, but they have taken two plea. That's what I'm telling. They have taken two plea. First is with regard to the limitation. Second with regard to the signature. Third with regard to the suspicious. Why you have waited till the 22 years for filing the suit? Filing an application or grant of probate, and you have waited till the death of the one of the all the attesting witness. Subsequently, you filed that. So that's why they are telling that this is one of the suspicious circumstances. One is second with regard to the signature appearing of the testatrix in the will are two ways. That is also suspicious. Third, they have stated they have taken the plea with regard to you had the knowledge the property belongs to two parts of the joint property. How it is possible that the Kiranbala can execute the will of the whole property? And fourth, once you have got the property in your name in the 2002 itself, so how you are telling that in 2013 you got the copy of the will, applied before the mutation and got the mutation, though the mutation has been affected in 2002 itself?
Your Lordship, as far as the mutation of the property is concerned, there's some conflict as to was it done in 2013 or was it done in 2002. Your Lordship, I'll come to that later, Your Lordship. But as far as
these are the main,
these are the five Your Lordship has noted. Your Lordship, as far as the signature of the testatrix is concerned, Your Lordship, why through the evidence, Your Lordship, I'll take Your Lordship through the evidence. And may I start with Nobunita's evidence, Your Lordship? Your Lordship, if Your Lordship just indulges me for a bit, Your Lordship, I do not understand as far as the signature is concerned. What was the dispute regarding? Are they saying that the signature was not of the testatrix, or were they trying to say that this testatrix never signed? So, Your Lordship, there was a line of questioning, and this is in terms of Nobunita's evidence, Your Lordship. Yes. So, Your Lordship, the only contention that they have, the only problem that they are saying that they have is that Kiran Bala Devi always signed as Kiran Bala Devi and never as alias Banerjee. Your Lordship, I remember that my senior had dealt with this point, and it is not in question that if she ever signed in English or not, because Nobunita herself had initially said that she never signed in English, and then there is a line of questioning, Your Lordship. I'll take you through the questions also, that she did sign, and she signed in English. The only contention is if she ever signed as alias Banerjee. Your Lordship, I remember my senior had submitted during that Kiran Bala Devi, yes, always did sign as Kiran Bala Devi Banerjee, Kiran Bala Devi. But as far as alias Banerjee is concerned, and the documents that have been led showing where she has tried to sign as alias Banerjee, the lady, the testatrix, having the habit of always signing as Kiran Bala Devi, is proficient in signing Kiran Bala Devi. But the minute she is asked for purposes of a legal document to sign as alias Banerjee, there is shakiness in her handwriting, Your Lordship. That alias Banerjee there's a lot of shakiness. And I remember, Your Lordship, and I'll take you through that document also, where she has signed as alias Banerjee, that there's a lot of shakiness in her signature. But as far as Kiran Bala Devi is concerned, that is not in dispute. They are only alleging that she never signed as Kiran Bala Banerjee, alias Banerjee. and that it is her signature, that is also not in dispute, Your Lordship. That she always did sign in English. There are certain checks and the questions, Your Lordship, if Your Lordship takes note of these questions. Your Lordship, question number 207, 208, and 214 of Nobonita's evidence.
Yes, they already pointed out, Mr. Datta already
Yes,
pointed
Your
out.
Lordship, that there was no issue when it came to that. As far as signature is concerned, this is what we have to say, Your Lordship. Now, as far as the third suspicious circumstance that Your Lordship has pointed out, that he had the knowledge of the will and why he waited for so long. Your Lordship, that we'll have to deal, Your Lordship, that properly.
That is a submission which they have made.
Your
Not the
Lordship,
court. What they have submission made brought to the notice of this court. That's why he put the question to you. Question 78, I think so.
very well, Your Lordship. I mean, there are certain questions that there are certain points that they have raised today, Your Lordship, which we would like to deal properly. And if Your Lordship gives another date, we'll come and properly deal with them. Whatever, right now, I understood, Your Lordship, and I could lead. I am saying, Your Lordship, but
Okay, come on the next. So appearing for the plaintiff, so appearing for the defendant. Counsel for the defendant has concluded his argument.
okay.
Counsel for the plaintiff raised for time to give reply to the argument made by the counsel for the defendant. Accordingly, case is adjourned. कल है क्या? नहीं कल है. Report का है? Name.
Your Lordship, if it's in the first week of April.
April on ছুটি আছে
No, it's second, that
First
is
week.
third week.
Yeah,
15th,
first week
11th,
of the-
11th to 15th.
Shoot में.
10th to 15th, हाँ.
Friday ना? Friday.
Like
20th March.
coming Friday, Your Lordship. Very well, Your Lordship, much.
28.
Yes, Your Lordship.
Time target
Any time fixed?
12:36.
12:30.
I am not giving the time, but it will be in the 12:30 slot. It will come.
Yes, Your Lordship, and we shall deal with all the contentions raised by
Okay.
them.
Yes.
Much obliged, Your Lordship.
My lord.
Sure.
Your Lordship, I appear for the defendant.
Yes. Item number?
15.
My lord, I am appearing for the plaintiff.
Your Lordship, I appear for the
And,
defendant. I am led by Mr. Varun Kothari. He is in courtroom 40.
My lord, they have made their submission for revocation of the leave under clause 12.
Revocation of clause 12, yes.
Clause 12 leave, my lord. My lord, the plaintiff has filed this plaint for damages and protection or protective order in respect of finished stocks of coking coal, my lord. And the part of cause of action has arisen within the jurisdiction, my lord, and part of cause of action has arisen outside jurisdiction. My lord will
He has not completed, I think. He has completed. Mr. Kothari has not completed.
No, Your Lordship.
He has to complete. Where is Mr. Kothari?
Sir, he is at courtroom 40.
So,
Sir,
come. Friday?
Friday, my lord.
Not today. But he's not here. What can be now? 3 p.m. other matter is there.
The 5 minutes pass.
5 minutes on the 3 p.m.
Fixed
Then 3
matter
p.m.
is
matter
there.
will be taken up.
Okay. Okay, not today. Grateful, your lordship.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Due to paucity of time, the matter could not be taken up for hearing. Accordingly, case is adjourned. This is the matter on 28 March. Huh? Yes.
Item number 16. I was arguing last day. I was in reply. Only a last leg of my reply was remaining. Recollect on the last day, Mr. Dotto or Mr. Shumon Dotto argued that I have filed an application seeking revocation of the leave under section 12A of the Commercial Courts Act. I relied on Yamini Manohar, paragraph 10, the compilation of judgments is having taken exhaustive note also. I have relied on paragraph 10 and a recent judgment of our High Court Division Bench of December 2024. That is serial number 8. Serial number 7. Page 68 to 70. Now, Mr. Dotto has relied upon two judgments, which are, of course, prior to the judgment that I have last relied upon. He has relied upon 2023 SCC Online Calcutta 2443 and 2024 SCC Online Calcutta 7817. Both are from the same bench. One is Srishti Infrastructure and another is Gabriel Metal Private Limited. Now, my contention was that it will immediately come back to your lordship's mind. In September 2021, they have filed the plaint. They have waited for more than 2.5 months for file an application. They have obtained the leave on 6th of September 2021 under section 12A. When I come back and file before the lordship's court the leave the application, this application seeking revocation of that leave, now after 10 days after that they serve me with this application GA3 seeking injunction. Now my issue was that I conversed before the lordship is that you have waited for till I file my application. So you have no urgency that you have contemplated, quote unquote, the word contemplated has given a much praise, much force by both these judgments. Will kindly take only one paragraph. I relied last week, paragraph 20, page 17. Page 17, paragraph 20 is part of the plaint.
Page 70.
Page 17, para 20. Only one paragraph.
GA2.
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 The part of the plaint. It's a plaint.
Yes.
The plaintiff has now come to know that the defendant and his directors are in process of transferring the assets, including the shareholding in their connected companies, so as to render the defendant company a shell company. There is a grave urgency in the matter, such leave 12A. This is the only paragraph. Now, what they have, this was in September 2021. Now, kindly takes GA3 that they have filed after my application. Kindly takes GA3. But they don't have a better case than this. Kindly takes GA3. Page 11, paragraph 24. That's it. Same. After 2.5 months, same. Page 11, paragraph 24.
Yes.
Copy pasted paragraph from the plaint. Nothing better than this.
Yes.
So, the contemplation of urgent release was only this. In 2021 September, 2021 December, still now they have not taken any step 7 except after becoming wise after file my application. And these are my reply to their argument, my rejoinder. This application is barred. Clearly the leave should be revoked. That's all.
Well, my very limited.
No, you can
question
rejoin
is
after the rejoin after rejoin. I have rejoined only.
Let me consider the unreported decision and come back to.
No.
Malad, what I was on, Malad,
my lord, considering a very hypothetical situation, my lord, that if the matter is sent to mediation, do they have the intention to participate in mediation? The reason why they are seeking the revocation, my lord. And if my lord, even assuming but not admitting, sends the matter back to mediation, will the suit be kept pending?
Don't ask question to the court. It's
Till such time, my lord, the mediation will be in process.
I raise my case, this one is rejoinder.
My lord, those are the two legs, my lord, and what my lord has said, my lord, as my junior pointed out. My lord, that
my lord wanted me to file a short note. My lord, we have already filed the notes.
Filed. My lord, we will distinguish the judgment, my lord. As I said, my lord, the unreported decision which my lord has cited.
It's already argued. I am in rejoinder. As far as you are not,
that is already argued.
I am
My lord, in the
rejoinder.
rejoinder, my lord, my learned friend has cited some new decisions.
No.
This is
I have not cited
the
any.
written notes already.
You are not
given.
ready.
My lord, the fact is, my lord, as my lord is aware, my lord, I am being led by Mr. Datta in this matter.
Correct. I know Mr. Datta is appearing. He has already given the answer to this side.
I was rejoining.
And he has only
Rejoined.
given the
Your function is over.
My lord,
That is order.
let Mr. Datta come back on another date, my lord. Let Mr. Datta substantiate his argument, my lord.
He can't rejoin to rejoin.
My lord,
understand what is going on in court.
My lord, my learned friend should not make such submissions. My lord, let him address his case with regard to his case, my lord. Let him not take my side and assume
Last day he was also
jurisdiction
not
on my
ready.
part, my lord.
I rejoined. After rejoinder, there is no more. Then I'll again reply. It will go on like this.
My lord.
You come to court.
My lord, I would beseech your lordship to kindly allow me 1 day, 2 days time.
After rejoinment for what?
My lord, regards the judgment that he
I
is
have not cited
pointed out in the
anything.
court.
This judgment, you are not having this.
His senior distinguished my judgments.
I have taken note of it, sir. I have taken note of it. Kindly see, I have taken note of it.
His senior relied.
Mr. Dutt has already dealt with this judgment. If you said that, if Mr. Dutt will say that he has not dealt with, then okay.
My lord, I am
I'm
under the
rejoined that.
That let him come back, my lord, and let him close this, my lord.
He has already
lost citing some other judgment.
His turn is over. I am in the last leg. I am in rejoinder. Then I'll also reply. It will go on like this. This is unfair
if
to me.
it has continued for such a long time.
I am fixing a week. Give the return notes.
Return notes. Very
yes,
Sons offering for the plaintiff, sons offering for the defendant. Defendant has filed an application GA2 of 2021 saying for revocation of due.
ডিসাইড করবে না জজ ডিসাইড করবে না আমি করব কে করবে বলো
under section
তুমি
12
তোমার
of the-
কেসটা দেখো আমারটা দেখতে দাও
under section 12 capital A of the Commercial Court Act and for dismissal of the suit. Hearing concluded,
করে
full
করছো
stop. The
মিডিয়েশনে
parties are directed to file their written notes of argument within a week. Full establish the matter on 4th of April 2025 has to be mentioned for filing written notes of argument.
Grateful, my lord.
May it please your lordship, my lord.
Yes.
I am appearing on behalf of the defendants in this suit, which is, my lord, for declaration and damages. And, my lord, my application GA2, your lordship had, my lord, heard extensively, is based on, my lord, it is, my lord, an application for dismissal of the suit and rejection of the plaint consequently. But it is based on two legs. First, that the plaint does not disclose a cause of action because the plaintiff has solely relied upon a police report. And under section 173, my lord, a police report is not conclusive because for the magisterial proceeding to come to an end, there must be, my lord, a verdict. So the claim for malicious prosecution based on the police report does not constitute a full cause of action.
What
that
has
has been
happened after filing of the final report?
We have, my lord, filed our Naraji petition, and that, my lord, we have disclosed with our application, and the matter is still pending. So, my lord, there is no conclusion to the magisterial proceeding where the police report was filed by the police authority. But in the meantime, the plaintiffs, my lord, claim that there has been malicious prosecution. Assuming that the magisterial proceeding has come to a conclusion, because of the police report, they have, my lord, raised a claim for damages before this honorable court. So we say, my lord, a malicious prosecution can only be termed as concluded once there is a verdict either in their favor or in our favor. If it is in their favor, saying that whatever was alleged is incorrect, then, my lord, the suit for malicious prosecution may germinate, but not prior to that. Since in this case it has been filed prior to that, we say that, my lord, this is not a proper cause of action for which this suit should be maintainable. The second leg, my lord, is, and my lord, I'm not taking your lordship, my lord, through the paragraphs in the pleading because, my lord, your lordship had taken note even while I had argued and Mr. Sen, senior advocate, had argued. The second leg, my lord, is that an incident has been complained of which led to the damages as well. And that particular incident, my lord, has occasioned outside the jurisdiction of this honorable court. So even that part of the cause of action is not covered within the four corners of this suit. Lastly, my lord, the plaintiff has sought for a declaration that certain transactions should be declared as null and void. But there is no consequential relief of injunction sought. And that is, my lord, barred by law under section 34. That provision was placed before your lord. This is, my lord, the contentions which we had raised before your lordship under our application. And Mr. Sen, my lord, on the last occasion had placed two judgments based on section 174 to, my lord, make your lordship appreciate the provisions of section 173 that it is not conclusive. Lord, these are my submissions. My learned friend may begin in reply.
That was short. I was under the impression that Mr. Sen would take today's time because on the last occasion when he had made that submission that he would need one more day to complete his arguments. Because I'll start today. No, very well. If my learned friend does not want to add any further, I'll start today, but I'll not conclude today because I'm also led by Mr. Abhijit Mitra in this matter. It kindly takes, the plaint which is appearing at page 19 of this application, my lord. The sum and substance of the case, plaint case, is that the plaintiff number 1, had received certain sums from several companies under the control of defendant number 2, my lord.
Yeah.
Now, my lord, these sums, my lord, were received sometime in the year 2018, which is about 4 crore rupees, my lord. Now, it's further the plaint case that this money was returned by the plaintiff, my lord, to the defendant number 6 and 7, who are admittedly companies under control of the defendant number 2.
Yeah.
This, my lord, will find at page number 7, paragraph 8 of my application. So, my lord, 4 crore received and 4 crores paid back to the companies in control of the defendant number 2. And, my lord, it's the plaint case. My lord, I'm sure, my lord, there'll be no quarrel to the proposition, my lord. When it's an application for demerit, this case as it appears on the plaint have to be taken on the face of the records. Then, my lord, the second limb of the grievance as shown, my lord, in the plaint is that, my lord, despite this fact, my lord, a frivolous complaint was lodged against the plaintiff, and this led to, my lord, an investigation. And eventually, after the closure of investigation, the police submitted a final report.
Yeah.
Final report in the form, my lord, saying that this dispute is wholly civil in nature, and therefore the allegations as it appears in the complaint, which led to the registration of the FIR, were false. But I have enclosed at page 63 the final report which has been submitted by the police. But this is also part of the plaint. But page number 66 is where, my lord, the facts of the case as investigated by the police is set out. And kindly comes to page number 70, where, my lord, towards the middle, the police after investigation has come to a finding, my lord. Later on, towards the middle at page number 70, my lord, later on, this amount of rupees 11.5 crores have already been refunded to Pradeep's company. Bank statements reflects the same.
Yes.
The investigation, my lord, came in my favor. At this stage, my lord, I filed this suit making two prayers. My lord. This suit, my lord, kindly comes to the prayers of my plaint, my lord. I claimed two reliefs, my lord, in the plaint at page 34. I claimed, my lord, a decree for a sum of rupees 10 crores towards, my lord, compensation for this frivolous complaint being filed against me. And prayer B, my lord, was declaration that no money is at all due or payable by the plaintiff number 1, or for that matter, any of the plaintiffs to the defendant number 1 or any of the defendants. So two reliefs. Now, my learned friend, my lord, on the last occasion had argued that termination of a proceeding, a plaint seeking malicious prosecution can only be filed once the proceeding finally terminates. It is further argued that once the police completes the investigation of a case, the report is placed before the learned magistrate. The learned magistrate has three options. One, it directs further investigation of the case if the case requires such further investigation. Or secondly, the magistrate can accept the final report and discharge the accused from the bail bonds. And thirdly, the learned magistrate can call upon the complainant, de facto complainant, to continue as a private complaint under 200 CRPC as it used to be. So these are the three options available. And according to my learned friend, since this decision of the magistrate was not there when the plaint was submitted, this plaint is perhaps premature. Now, this is the first limb of argument. I will cite some cases which perhaps it is not as clear. The proposition as placed by my learned friend perhaps is not correct, and I shall persuade my lord to believe that at this stage, when the police completes the investigation, a plaint can be filed. This would be my first endeavor to show. But the second, which perhaps will save a lot of time, even assuming for the sake of argument, let's assume for the moment, that this argument which my learned friend makes is correct. But this takes away only a part of the plaint, because a plaint, my lord, is fully aware cannot normally be partially rejected. There cannot be any partial rejection of plaint. So the plaint has to be there or has to go completely. Now, so far the second relief is concerned, the fact that I had paid the money back, and there are instructions on record, there are documents on record to show that the defendant had instructed me to pay to their nominee or companies in their control, is something which is a tribal issue, has to be decided on trial. And therefore, my lord, this cannot be said to be, this is the case that is made out is that this is barred by section 34 of the Specific Relief Act. That is the case made out. Because according to my learned friend, there is no consequential relief that I have claimed. Kindly looks at my prayers, that the reliefs that I have claimed in the plaint.
Declaration.
I have asked for declaration, and there cannot be any consequential relief after this, my lord. I say that I have received a sum of money from a plaintiff defendant number 2, and I say that I have repaid it to the other defendants who are companies in control of the defendant. If this relief, if I succeed in this relief, this is a complete relief that I require in these facts, and therefore, there cannot be any further consequential reliefs on this aspect of the matter. But I wanted to cite one case on this proposition.
So if you're claiming the damages of rupees 10 crore on the basis of the police report, on the ground that the police has already come to the conclusion it is a civil suit, civil dispute, and second 11 point some crore has been paid by you to the defendant. So there is no, if it is the evidence over there, and why you are praying for the declaration here?
This declaration has to be from a civil court. Police making a statement by police perhaps will not suffice, my lord.
Because the plaintiff, the defendants have not filed any claim against you.
Yes, my lord, there is a prior suit. That is it. That is the factor which which led to this suit. There is a suit that we are claiming.
So yes, there are other suits also, my lord. So, my lord, this declaration perhaps would be necessary, my lord, for me to defend the other proceeding, my lord. So ultimately, it will be an analogous trial, and at this stage, my lord, how can this be decided? Where I have shown there are documents where I have been instructed to pay to the other defendants who are in control of the plaintiff, defendant number 2. So therefore, my lord, this relief was sought for, my lord. But I wanted to cite, my lord, let 2006 volume 7 इसमें है क्या? Let 2 cases, my lord. 2018 volume 11 SCC 780. My learned friend can take a note. 2018 volume 11 SCC page 780, and another case is 2019 volume 7 SCC 158. Both, my lord, on the proposition that there cannot be any partial rejection of my plaint.
That's correct.
This is on this aspect, my lord.
That is settled.
Settled. Now, with regard to, my lord, the specific relief, my lord, point, my lord, but I am extremely sorry, my lord, not carrying all the cases today, my lord. I would rely on 2006 volume 7 SCC 296.
2006
volume 7 SCC 296, my lord. To argue, my lord, that I'm sorry, my lord, it kindly takes another judgment, not this one, my lord. I wanted to rely 2022 volume 8 SCC 633, paras 41 to 44.
Of the specific relief?
Yes, my lord, on section 34, my lord. That this cannot be a ground for rejection of plaint under order 711. Even if it is a ground, this cannot be a ground for rejection of plaint.
One of the issues.
Yes, my lord. That this is on the proposition that section 34 argument, perhaps, my lord, even if it is accepted, will not be, my lord, good enough to have my plaint rejected on the face of it. But I am really, my lord, embarrassed, my lord. Kindly fix a date, my lord. I shall come back with these cases, my lord. And, my lord, I shall cite and close my submission. It won't take much time, my lord.
Okay. Census and suffering for the plaintiff. Census and suffering for the plaintiff. Counsel for the plaintiff has argued the matter at length, but due to press for time, accordingly, case adjourned. Let the matter appear. Time is the difficulty now.
Any day, my lord, any day. Let it appear.
Let the matter appear on 7th April.
Very well.
Under the heading adjourn motion.
Will the lordship be pleased to fix any time, my lord?
Time, that's soon. Adjourn motion.
Because this is going on for some time. Anyways, I leave it to your lordship. Some preference on top of the list so that we can.
My learned friend has sought at least 5 adjournments in this matter.
Yes, we had to, but again, my lord, we argued and then again.
And today I'm handicapped, but literally I'm handicapped. I'm deeply honest.
Obliged.
Item number 17.
Your Lordship, I appear for the defendant in this matter.
Lordship, I am operating on behalf
Their
of the
application.
Plaintiff in this suit.
Yes.
17. I'm praying for short passover, my lord. Mr.
Who has
Tiwa.
filed the J1, J2?
J2, your
Plaintiff has
Lordship,
filed an application.
their
J2
application for
judgment upon
order
application.
12
Who is for the
26.
plaintiff?
I'm for plaintiff, my lord, in this suit. I'm praying for short passover, my lord.
Why?
Mr. Tiwari appearing in this matter, he is on his leg before 37.
Lordship, I will
Ready?
want to post
Affidavits
that.
completed?
Pleadings are complete in this matter. your
Pleadings आ गया?
My lord, last time my lord had given direction to file affidavit in reply. My lord, reply is ready within time. My lord.
We've received a copy of it, I guess. I'm presuming
My
my
lord.
learned friend will have to file a
My lord, I have served to the other side also.
Oh, my learned senior is here.
Yes, Mr. Tiwari, you have filed the reply?
Yes, my lord. Given copy. Copy, I have received. Duly received.
Where is that? It is not filed in the court.
Not I will hand over the original
Huh?
in my brief. I'm just handing over.
Ready?
Right, yes. Whole volume.
Reply of 4 volume.
Your Lordship, the entire plaint with the annexures has
Not all
been...
the annexes of the plaint I have to only because there is bare denial, as if there was no transaction. Not my application, not for judgment of an admission. My claim, I have not delivered the goods to the defendant. And in short minute, may I tell you the facts of the case. I delivered goods for 11 crore 86 lakhs to the defendant. They received the entire goods, they consumed the goods, and then they made part payment. But they have made not 10 crore 61 they have paid. Balance 1 crore 25 lakhs is due. For that they issued a check, 125. Check was dishonored. I filed my lord the 138 in the court below for bouncing of the check. Now in the suit, they have annexed in their balance sheet. My claim is admitted in their balance sheet. That what I will show to Lordship. And kindly see the reply there too. Total denial as if there was no sale and purchase, only one transaction. They agreed to pay 125. I did not perform that. That is why peculiar defense they have to. Kindly come to few paragraphs of the plaint. And extra I have made in my petition.
Yes.
This is not plaint, short plaint. I will place 3-4 paragraphs. Plaintiff is a private limited company, so Lord, defendant number 1 company was initially incorporated as a private limited company on so and so date in the name of so and so. Then Lord, kindly turn the page, paragraph 4 onwards. Sometimes during 2019, defendant approached the plaintiff and represented that they were in the business of trading of coal. The defendants represented that they required various qualities and quantities of the coal, and as such had approached the plaintiff to meet the demand of the customer. Series of meetings were ensued between the parties, wherein the defendant sought supplies of coal from the plaintiff, and the terms of condition of the sale was deliberated between the parties. Such meeting took place so and so. In pursuance of the aforesaid, plaintiff made supplies of coal of the various quantities to defendant number 1 from time to time. Cumulatively, the plaintiff supplied goods worth rupees 11 crore 86 lakhs so and so to defendant. Defendant number 1.
Order 12, Rule 6.
Yes, my lord.
Okay.
Lord, defendant number 1, company against invoices delivered the registered office at so and so, aggregating to rupees 1186. I have delivered the goods for 1186. Now, Lord, kindly turn the paragraph 6. Since the parties maintain a current and running account, the defendant number 1 made part payment aggregating to rupees 10 crore 61 lakhs. And still 1 crore 25 lakhs 50,000 still remains due and payable against the aforesaid invoices. The copy of the ledger maintained by the plaintiff so and so are enclosed. Plaintiff received the last payment of 13 lakhs on 16 November 2020, and thereafter an amount of 125 remains outstanding. Further, the plaintiff company had on several occasions sent reminder by electronic mails to the defendant regarding the payment of the outstanding dues. They did not make payment. Similar paragraph 9. Since the meeting held in this is regarding jurisdiction. Para 9. Kindly see the 5 checks they have given for the balance payment of 1 crore 25 lakhs. Page 11, my lord. Yes. Para 9. These are the detail of 5 checks. As per the instruction of defendant number 1, plaintiff presented the aforesaid checks for payment of his bank account, but the aforesaid checks were dishonored and returned unpaid with the reason exceeds arrangement. Then, Lord, paragraph 11 is a jurisdiction.
Where is the document regarding work order? Have you issued the work order?
It was issued, my lord. Print there. That's okay. Print there. Lord, I have not in my reply. My Lord kindly takes note the first annexure. Page 17 onwards, my Lord, these are the invoices from page 17 to page 29. These are the invoices, my Lord, we have raised to the defendant for the supply of the goods.
No, these are the details of invoices. You have prepared it.
Yes,
Where is
I have sent it, my Lord.
Where is the invoices?
My Lord, page 30 and onwards, can you see?
Page 30 onwards.
Yes, all the invoices so far made raised upon the defendant.
Okay.
Page 30 onwards.
So this is the Agrawal. Plaintiff is Agrawal.
My Lord, Agrawal Kohli is the plaintiff.
RK.
RK Commodity is the defendant.
Buyer is RK, yes. So these are the, these all invoices.
Yes, all the invoices, my Lord.
Okay.
It has become voluminous.
Up till page?
Lord,
Up till
from page 32. Page 32. Page 40, 440, 450.
450.
All these my invoices I have annexed because of their opposition. I have just placed 3 paragraphs of their opposition. Then I will take you, no, may I take you to the admission part. Will kindly come to my petition. Not page, kindly come to page not 25. Sorry. No, page 24. It's a balance sheet of defendant.
Yes.
And HSC. Now, kindly see, my Lord, in the first heading equity and liabilities. If you Lord, you kindly come head note B, current liabilities. That's B, trade payable other than micro and small industries. This is not heading. And now, Lord, you Lord will find detail of the B at page 5 of the balance sheet.
Page?
Page 30. Note 5. Here, note B, trade payables, note B, note number 5. Now, you kindly come to note number 5 at page 30. Current liabilities. Sundry creditors of goods. Sundry creditors. My Lord, got it, my Lord?
Yes.
Sundry creditors.
Yes.
Now, this 15 crore. Now, my Lord, kindly come to the list of sundry creditors. Page. Page 36. List of sundry creditors. As on 30th March 23. Number 1, Agrawal Coal. Number 1, Agrawal Coal. 1 crore 25 lakhs. That is the amount they are admitting in their balance sheet. It's their balance sheet. It is the balance sheet of defendant number 1.
No, what from 30 what you want to show?
No, from 30, my Lord.
Note 5.
Note 5.
Sundry
Sundry creditors for goods. Now this note 5, my Lord, you Lord will get it, sundry creditors, page 35.
Page 35.
List of all creditors, of their creditors. No, sorry, 36, my Lord. 36, in the middle, my Lord.
Acha, sundry creditors.
Sundry creditors, number 1, Agrawal Coal. 1 crore 25 lakhs. This amount they have admitted in their balance sheet of 2021.
Yes.
But this is, my Lord, in substance my case, that since my claim is admitted in the balance sheet, I am not entitled for a decree under R 12(6). Lord, kindly Lord come to their opposition. What is their?
Where is the check? Where is the check?
Checks. No, check they have issued. Sir, your case is that you have
supplied the materials of the 11 crore something, 10 crore they have paid, 1 point something is there, they have issued the check has been dishonored. So you have filed the case and you have filed the suit. So you have to place before the okay, you have given the this with regard to the supply order. With regard to and where is the check issued?
Note, kindly come to page 602, one check 605. It's not volume number
602,
605, 605, 607, 608.
So that's a
608 and 609.
what is this reason for dishonor?
Exceeds arrangement.
Have you issued the notice to them?
Yes, 130 notice issued.
Where is the notice? What is the reply?
Volume. Page 521. Last volume, last volume. Their reply notice is not annexed.
Then you send the notice whether they have sent any reply. Have they sent any reply?
I have to check up, but they are contesting the 138 proceeding filed in the.
That is correct. Yes. Have they sent any reply? What is the difference in the reply?
That should have been annexed. Yes.
What is the defense they have taken?
Not the defense will not kindly come to page 5. Peculiar defense.
Page 5. Page 5 the affidavit.
Yes, my lord. Opposition.
Yes.
Quote A, my lord. This is the case. About 2019, the directors of the plaintiff, Mr. So-and-so and Mr. So-and-so, approached the defendant respondent 2 for supply of coal and assured that the best quality of the coal at low market price would be supplied upon the condition that respondent number 1 would have to provide blank checks. Based on the aforesaid representation and assurance and believing the same to be true, respondent number 1 along with the cover letter to so-and-so issued 6 undated checks to the plaintiff bearing number so-and-so drawn on the Bank of India, Rajbihari Avenue branch for cumulative amount of 1 crore 50 lakhs. In terms of the condition of the business arrangement, a copy of the said letter dated so-and-so is enclosed. Among these 6 checks, as referred herein above, it was agreed that plaintiff would only utilize the first 5 checks, number so-and-so, for rupees 125, subject to the plaintiff supplying coal of the agreed quality. However, the plaintiff supplier in inferior and degraded quality of the coal, which could not be used by respondent number 1. As a result of the same, respondent contacted the representative of and directors of the plaintiff, informing them about such inferior and degraded quality of the coal supplied by the respondent number 1, which could not be used, and thus supplied coal ought to be taken back by the plaintiff and aforesaid 5 blank checks be returned to the respondent number 1. But no such document is annexed to the. Despite such repeated request of the respondent, the plaintiff paid no heed to such complaint, and respondent number 1 and the furtherance of the malafide intent to harass the respondent and to extort money, plaintiff deposited the 5 checks. Plaintiff had deposited the said blank checks with the motive of the harassing the respondent and causing wrongful loss on the respondent number 1, thereby effectuating wrongful gain upon himself. Plaintiff had not also deposited such checks, knowing fully well that respondent number 1 owed no debt to the plaintiff. Plaintiff has further sent an illegal demand notice dated 26 August 21 without any basis, making an attempt to intimidate and coerce the respondent number 1 to pay the plaintiff for the inferior and degraded quality and coal supplied. The respondent number 1 rejected such illegal and unlawful demands of the plaintiff on account of inferior and subpar quality of coal supplied by plaintiff. Further, the respondent crave leave to produce such reply. It is not annexed, my lord. Reply is not annexed. Further, thereto plaintiff file a frivolous application under section 7 of the IB code, being so and so, with intention to harass the coerce the respondent, and however the said application not being tenable in law, the plaintiff has withdrawn the same. In fact, April 27, 2021, respondent number 1 has lodged a diary. Yes. Lodged a diary to GD number so and so with here is the police station. Inter alia lodged a complaint for return of the aforesaid check by plaintiff as the respondent number 1 owed no lawful dues. Yes. I have never heard, my lord, that somebody will lodge a complaint to FIR to the police station that I have given a check, he is not giving back to me. But they have lodged the complaint. No, that is not. It is not forged. I will show it. Copy of the general diary. I will show it to your lordship. No, this is, my lord, the fact in detail, as if that I agree to.
When the check was dishonored.
Lord, check was dishonored. Date देखो. Last बोल.
11th
I have annexed the memos.
11th March.
I have annexed the memos. All the 5 memos issued by the bank.
All 11 March, yes.
All
and when the complaint was lodged?
27th April. 27th April in 2021. I'll just indicate your lordship, my learned senior is in his usual fairness and eloquence placed the facts. Your lordship, if I may just put this to context. Oh, I apologize, your lordship. I apologize.
No, kindly see, my lord, paragraph 7. Paragraph 7, my lord. Instant suit instituted against the defendant inter alia for degree of 1 crore 62 lakhs is misconceived both in law and facts. It is denied that the writ of summons were served upon defendant, and despite receipt of summons, defendant have never appeared as alleged. In light of the pre-existing dispute between the plaintiff and respondent with respect to the substance standard quality of the coal, there is no amount due and payable to the defendant, to the plaintiff. In addition to the same, there is no clear, unequivocal, unambiguous and specific admission of any outstanding amount in favor of the plaintiff. With reference to the respondent number 1 had not admitted rupees 125 in its audited balance sheet for so and so year. It is denied that disputed that the claim of the plaintiff amounting to rupees 125 has been admitted by defendant number 1 in their balance sheet for so and so year, appearing under the heading trade payable as alleged at all. It is submitted that there is no specific, unequivocal, clear and unambiguous admission by defendant in the balance sheet. The purported acknowledgement as alleged by the petitioner in the balance sheet would not further any admission intending to admit the juror relationship between the parties, and as such, the entries in the balance sheet cannot be fastened by way of the reasoning and or conclusion. In fact, there is nothing in the said balance sheet to remotely proffer any outstanding liability of the respondent 1 towards the petitioner. Now, it is denial of the balance sheet, contains a balance sheet, that it doesn't amount to admission. But this amounts to perjury because it's a false statement. There is admission of the claim. Allow me to place order 12-6. It does not qualifies any such condition that it must be admission must be unequivocal. Order 12-6.
Notice इसमें हम लोग इशू किए थे नोटिस अंडर सेक्शन 7 ऑफ आईबीसी। उसके बाद सेक्शन 8 का हम लोग एप्लीकेशन
ऑर्डर 12-6
ऑर्डर लगा हुआ है यहाँ पे।
मतलब काइंडली हम लोग order 12-6, what did you say? Judgment upon admission. Where admission of fact has been made either in the pleading or otherwise, whether orally or in writing, court may, at any stage of the suit, either on the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. Whenever a judgment is pronounced under Rule 1, a degree shall be passed. Similar clear admission of my claim in the balance sheet. That is why I was claiming, Lord, kindly pass the decree, Lord, for this amount, because there is no defense at all to the defendant. And Lord, secondly, goods delivered, never complained. Goods consumed, never complained. Then Lord, as per the Sale of Goods Act, when you admit the receipt document, the goods, and consume it, then Lord, the liability is there. You have to pay the amount. You cannot say after 2 years that no goods were defective and therefore there is no liability. काली मिलोट पास the judgment मिलोट as claimed.
डिमांड नोटिस जो पूछ रहे थे हम लोग
ठीक है,
कर दीजिए
बोलो।
With your lordship's leave, if I may just address your lordship on the limited circumspection on the context in which my learned seniors, in the limited circumspection on which the context on which my learned seniors place the facts, I will not. The only limited submission that I make, your lordship, with respect to the complaint, as your lordship has seen, this was an oral agreement. Your lordship, everything the parties they have understood the business relations, they have been proffered on the basis of oral agreements and understandings, as is the business arrangement between parties in such transactions. Your lordship, subsequently, when this particular quantity of coal was received by us, we had intimated to the plaintiffs several times.
Where
Of
is
course,
that?
of course, your lordship, again, due to the embargo that I'm facing over here is that all of this is based on oral and calls and oral representation. So I do not have a case wherein I can adduce that. The only aspect, your lordship, if I may just place the complaint which I've made before the High Street Police Station, your lordship. Over there, your lordship, with respect to the checks, when I've already made a representation to the plaintiff that I am not using this X amount of coal that you've supplied to me, it is
That's
defective in
why
nature, you take it back.
when it was supplied to you,
Your lordship, it was supplied in the month of February and partly in March. I have made the complaint in April,
you made the
after the
complaint
checks have been
very
entered.
well. If you have received the materials, correct, and if it is the degraded quality of the materials, it is you to immediately inform or return the material back. These two are not on record.
I bow down.
These two are not on record. Secondly, the checks, it is not one check, it is the 5 checks. You have issued the 5 checks, or checks have been dishonored. That is on 11th of March 2025.
And subsequently, the embargo that I'm facing is that I make the complaint in the month of April, that also in the last leg.
So you have received.
I bow down.
So now you cannot say that you are not aware with regard to the dishonor of check. Now nowadays, within a second, your phone will speak whether you have received any check has been received in your account, whether it has been dishonored.
I bow down to your lordship.
Correct.
Your lordship,
So it is a March, 11th March,
11th
and
March.
you made a complaint in the month of April after a month.
I bow down to your lordship. Your lordship, essentially speaking, my learned seniors place the facts in his usual fairness. Factually, because of these embargoes that these are not on record, I do not have a case factually. Your lordship, in that case, if I may just make an attempt to showcase, or I need not embellish the wisdom of your lordships through any judgment, but if I may just traverse for my understanding the judgment, because the onus over here, my learned friend has placed the balance sheet over here. So the question of an Order 12 Rule 6 admission in cases of a balance sheet, it is a notch higher than it is in the usual course of things. Maybe it being a letter where I have specifically admitted. Your lordship, my second submission would be that my learned senior, of course, I seek his guidance in this regard. Your lordship, he says that there need not be any clear, unequivocal, unambiguous admission on my part when I'm proffering an admission with respect to any ambiguity. Your lordship, Mr. Datta happens to lead me.
Just 2 minutes.
Your lordship, if I may just place two judgments. One, of course, your lordship, Mr. Datta has guided me in this respect, Uttam Singh Duggal. And the second one, your lordship, again, I need not embellish your lordship's wisdom with this. Your lordship, with respect to a Delhi High Court judgment, if I may just place it with your lordship, because in a balance sheet, the intention wherein I am proffering an admission, that must be with the intention that I am admitting certain dues or certain balances in that regard. Your lordship, over here, that is not the case. Your lordship will just kindly take up page 680 of their reply, your lordship, wherein
600 and
680, your lordship would find that
18.
680 because it's numbered as
80.
the 680.
Their last page is 61.
No, your lordship, it is numbered as in their plain page number. Page number.
No 680.
The last page is 612.
Your lordship, I'll just assist your lordship with the page number. Your lordship, wherein my learned friend, learned senior, आपने दे balance sheet है. Your Lordship, this would be Lordship, it's marked as page 680 in my document. If your Lordship is taking up their application once, it's an annexure to the plain, wherein they have annexed the plain, page 680. It's numbered as page 680. I'll just try and assist your Lordship in this. 680, the last page wherein the plaint has been adduced. That's internal page number. If your Lordship is.
That is page of the plaint.
Page 30. That's what I'm saying, your Lordship. 13. I 30. Apologize. It's not marked in my brief, your Lordship. Page 680, the balance sheet, your Lordship will see current liabilities, state payables, under that sundry creditors for goods, your Lordship. Then, your Lordship, page number 36, I will presume, of your Lordship's brief. It would be page 686 marked to the plain.
Yeah.
Your Lordship, the first entry, Agarwal Coal Corporation. Your Lordship will kindly see the date, your Lordship. 31st of March 2021.
Correct.
This is after they've encashed the checks. Your Lordship, this my police complaint or my wherein I've disputed the quality of the goods that have been contemplated to me. This is after that is after this period, your Lordship. So, your Lordship, this particular mark, the Agarwal Coal Corporation, to the extent of 1,25,50,000, your Lordship, this does not proffer any admission on my part, wherein I have made an entry into the balance sheet with the intention of ascribing some liability upon me to the extent of an Order 12, Rule 6.
Because of the check issued by you.
I bow down, your Lordship. I bow down. Your Lordship, in that regard, may I just, for my understanding, your Lordship, place the judgment of the Honorable Delhi High Court once, your Lordship. I'm carrying one copy. I apologize. The citation is 2013.
You do one thing, come on the next day. I have some fixed matter.
Very difficult task, my lord, we have. We understand that. We'll give it a try. And in the meantime, I'll also have a word with my advocate on record. I understand what is playing through your lordship's mind. If anything can be workable, otherwise we know, my lord, the fate account. At times it's difficult, my lord, holding this kind of brief, but we have to.
That is then only you require a good lawyer to revert the. My lord.
Grateful to you.
My lord is keeping it on.
Sense and suffering for the plaintiff, sense and suffering for the defendant. The plaintiff has filed an application being GA2 of 2024, GA, 2020, praying for judgment upon admission. Counsel for the plaintiff has concluded his argument. Police counsel for the defendants argued at length, but due to paucity of time, hearing could not be completed. Accordingly, case adjourned. Let the matter appear. 8th April.
Grateful.
Yeah, my lord.
Yeah.
Yes. Lord, this is that subway matter. I had completed my.
Lord, my learned senior friend's application was regarding referring the matter to the arbitration because the PTA has an arbitration clause. Now, my case is.
Host has stopped it. So, काय करायचं? My lord, I'm sorry. I'm appearing for defendant number 2. I'm not able to see the proceedings because the video has not been turned on. Yes, now it is. I'm sorry, my lord. No, still not on.
Jyoti International.
Yes.
Yes. I'm sorry.
That is here.
And I was thank God I could make this, I could appear in this matter. Millard, I've been missing matters after matters in this court from morning. One at 2 o'clock fixed, Millard, I missed it. Then the good faith, I missed it. But Millard, I was stuck somewhere else. That's why. Millard,
that's why I put the 2-3 questions to your junior. He told me that some time may be given, he will prepare to that.
Millard, here, Millard, I was addressing your lordship on the question of the arbitration agreement. Facts, Millard, if I may just indicate to your lordship, Millard, very briefly, there was a business transfer agreement. This business transfer agreement was floated by the defendant. Yes. He wanted to acquire my property. And thereafter, Millard, he himself volunteered to say that no, the business transfer agreement is not there anymore. And if you want to now sell it, we will have to reduce the price. And the cause of action is, Millard, a notice that was given that I am not keeping my store up to the mark, and therefore he wanted to terminate. And I came rushing to court saying that, look, he had agreed to do it, and thereafter, Millard, he is taking steps which are malafide. And now, Millard, two things, if I may just point out to your lordship, Millard, the impugned notice, which is at page 190, GA2 to GA1. GA1 na GA2 এটা impugned notice toda lagai ni of GA1, Millard.
Yes, Nanda. Yes.
Now, Millard, page 190. Now, Millard, I am trying to, Millard, read this notice vis-a-vis, Millard, the second requirement of being an arbitration, exchange of letters and correspondence referring to the agreement of arbitration. This was the impugned cause of action. Kindly, Millard, see.
Page
190.
190.
Of GA1.
Yes. Yes.
Pre-termination notice under franchisee agreement dated 19th October 2012 between Eversub Private Limited, formerly Subway Systems Private Limited, and Unju Das. This is an agreement of 2012. We refer to a franchisee agreement of 9th of October 2012 franchise agreement entered into between the company and Unju Das for setting up and running operation, maintaining such and such. You are a restaurant, you are such as updated from time to time, capitalized terms not defined herein shall meaning ascribed to it under the franchising. As communicated to in our prior communications, as per the terms of the franchise agreement read with the operation manual, you are required to remodel. However, as on the date of this letter, despite our timely reminders, the communication issued to operators of all Subway restaurants in India bearing South Asia remote restart on our internet portal on 2nd January available such and such, and the push notification in relation thereto, which was issued to you on your registered email. The letter of 13th February 2013 titled Intimation in relation to remodeling in case, reminding you and requesting you to initiate process of remodeling at the earliest to avoid breach of your obligations under the franchisee agreement. You have not placed any order under this any order with the consolidator or remodeling supplies, and therefore you have not completed the remodeling of the restaurant despite the due date of your remodeling having done go by. This constitutes a breach of your obligation under the terms of the franchise agreement, which entitled us to enforce our remedies under the franchisee agreement. So, Millard, the cause of action was enforced breach of the terms of the franchisee agreement and his remedies to enforce the franchisee agreement. The franchisee agreement is of October 2012. Please be advised that failure to correct this subsisting default immediately and in any event no later than 60 days of the issue of this notice will result in automatic termination of the franchisee agreement on expiry of 90 days within notice without any further notification. Then, as on the date of this letter, we observe that there are subsisting breaches of your obligation under the terms of the franchisee agreement, which entitle us to enforce our remedies under the franchisee, included but not limited to imposing applicable late fine, penal, such and such. This notice is without prejudice. So, Miller, the cause of action was this notice. This notice was issued under an agreement of 19th October 2012 franchisee agreement, which, Miller, also contains a separate arbitration clause. The 5 and 8 application, which has been filed by my learned friend's client, now, Miller, if your lordship kindly takes
Yes.
5 and 8, Miller, if your lordship kindly sees, he is trying to enforce.
Yes.
Now, Miller, if your lordship takes the GA2 side by side, he says that the agreement of 16th of December, it is respectfully submitted, paragraph 8.
Paragraph 8
of GA2.
Yes.
It is respectfully submitted in view of the arbitration clause contained in the business transfer agreement of 6th of December 2023.
Yes.
A separate agreement. The respondent number 1 has invoked the arbitration notice of 7th August 2000 in terms of the arbitration clause, referred the matter to arbitration for Singapore, which has already been received by them. A copy of the notice is such and such. Then the arbitration clause contained in the BTA dated 6 December 2023 is filed on record with this application as referred herein above. It is respectfully submitted that is settled law that considering the admitted position of the parties to the suit about the BTA dated 6 December 23 and consequently the existing arbitration clause agreement, the disputes raised by the plaintiff of the suit are bound to be referred to arbitration in terms of the arbitration clause by this honorable court in view of the aforesaid jurisdiction to try and determine. And now kindly come to the prayer. Under the circumstances, it is prayed that this honorable court may be graciously be pleased to stay the proceedings of the suit, whereby vacate the interim order of injunction and pass necessary orders directing the matter of disputes covered under ABC to be referred to arbitration in terms of the arbitration agreement, arbitration clause before the SEAC, for which notice of arbitration of 7th August has already been invoked by the respondent number 1. So, Miller, it is not the 19th October 2012 arbitration agreement which is sought to be enforced.
Yes.
What is sought to be enforced is, Miller, an arbitration agreement in the business transfer agreement, which admittedly, Miller, between the parties has not seen the light of the day. What I was trying to impress upon the court is this, that it is true that an arbitration agreement under the Act has certain criteria to be fulfilled, which has been circumscribed in Section 7. Section 16(2) of the Act says, Miller, that an arbitration agreement, even if contained in another agreement, will be treated as a separate agreement. Now, my endeavor was to show to your lordship that the Arbitration Act makes refers to an arbitration agreement as an agreement. For that, Miller, if I may take your lordship to Section 7, this is where I had left on the last occasion. Arbitration. If your lordship is at section 7, your lordship will find that subsection 1 starts with a very important. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have risen or which may arise between them in respect of defined legal relationship, whether contractual or not. So, an arbitration agreement has been referred and defined in section 2.
Right.
Arbitration agreement means an agreement referred to in section 7. Now, the difference which the legislatures in their wisdom have made is that an arbitration agreement may be in the form of an arbitration clause in a contract, which means, my lord, the larger agreement, or in form of a separate agreement. So, subclause 2, my lord, talks of two different things. One is there has to be a contract in which the arbitration clause is inbuilt, or it is in a separate agreement. Here, my lord, it is contained in a document which has not yet reached the stage of a contract.
So BTA has not come.
Because BTA, admittedly, my lord, BTA, they have walked out of it, saying that it's no more enforceable. So, and the sorry, and my lord, the document, which is a common document, will also show that it was not even been signed by them. So, therefore, now let us take it, my lord, what was the intention? Had this agreement been signed, which contains an arbitration agreement, then this arbitration agreement would have come under 7.4.7.3, read with 7.4a. Had this contract been signed, then it would be an arbitration agreement in writing. An arbitration agreement is in writing if it is contained in a document signed by the parties. So, had the contract been signed, this arbitration agreement would have come under 7.4a. Now, this contract is not been signed, which is admitted. If it is not signed, then how am I to know that I am bound by an arbitration agreement? Because he is not signed, there is no concluded contract. So, the legislatures say that it can be done also, even if it is not signed, by exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic message, 10 million, which provides a record of the agreement. So, therefore, meaning thereby that by exchange of letters and correspondence, that it would show that there was an arbitration agreement by which I was bound, because it was not signed. So, therefore, my learned friend would have to show that there have been exchanges and correspondence between the parties referring to the arbitration agreement, not the contract. Parties have, my lord, written letters which refers to obligations under the contract of 2012, number 1. The 2023 agreement, which is, my lord, the BTA agreement, which is sought to be, my lord, arbitration clauses, does not reflect in any of the correspondence where it says that you are bound by that arbitration agreement under the 2023, therefore you go before the 2023. Number 2. Number 3 is, my lord, an exchange of statement of claim and defense in which existence of the agreement is alleged by one party and not denied by the other. That stage has not yet reached. There is no statement of claim or defense. The reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing, which means any one of them, and the reference is such as to make the arbitration clause part of the contract. This, my lord, is generally, my lord, we use it for the purpose of arbitration agreements by incorporation. tender document referring to the general terms and conditions. Here it is not the case because the arbitration part is part of the BTA itself. So now, my lord, if I may formulate my points. My first point is my immediate cause of action to come to the court is the disputed notice which I showed at page 190, which refers to non-performance of my obligations under the BTA.
Yes.
Under the franchisee agreement of 2012. That was the cause of action. He wanted to terminate. I came rushing to court. That dispute.
Yes.
That dispute, that cause of action of mine can be governed either by the 2023 agreement or the agreement they are under, but it does not in any way touch the BTA.
How the BTA has come in?
I'll tell you, Lordship. Millard, I was actually carrying on business as a franchisee of the defendant number 1.
Correct.
Defendant number 1 is a foreign company. It has certain associates who is the BTA defendant number 3.
Correct.
Now, defendant number 3 and 4 decided that there would be some stores which they will acquire and will run. This may be a policy of the defendant number 1, but they are all separate individual parties. So what happens, my lord, the defendant number 4 gives me an offer that you have 2 stores. I am ready to buy off these 2 stores of yours. This is an agreement which he enters into with one of the franchisees, holding a franchisee agreement with the principal. Correct. He wants to buy it me. I say, very well. You buy off, they quote a price. I said, okay. They wanted to buy 2 stores. One they have already bought. So far as the second is concerned, my lord, they gave me a BTA agreement which is prepared by them. They say you sign it. I said, very well, I'll sign. I have signed it and I've sent it back. Once I send it back, they say, no, I am not agreeable to sell it anymore. Number 1. And the BTA agreement has automatically come to an end because it was not signed within the time which it was supposed to be signed and concluded. So they say that between you and me today, there is no BTA agreement. Thereafter, they go on to say, which exposes their malafide, thereafter they go on and say that, very well, I am ready to now buy you, but a much, much reduced price. So I came to court and said that, look, here is a person who is now initially gave me an offer which he did not accept. Thereafter, he is giving me a throwaway price to sell up my business. And to compel me to go into that, he is coercing me to go into that. What he has done is, my lord, he has given me a notice under the 2012 agreement that you remodel. If you don't remodel, I'll terminate. So once I terminate, so what he couldn't get by this hand, he is trying to get it by the other hand. He is not going to pay. He is not going to, my lord, go by the usual process of paying and taking over. He will just, at a throwaway price, take away my right and business and all the investments that I have made. So therefore, he started pressurizing me otherwise. That is what I came to court, and your lordship was pleased to observe that, no, once you had said that there is an issue to be gone into, there is a tribal issue. Thereafter, they come up with this saying that the court. Now, my lord, so far as the parent cause of action, one of my causes of action was that there has been no breach of the 19th October 2012 agreement, which is not the subject matter covered by arbitration. Number 1. Second cause of action was, my lord, I am asking my learned friends' clients that you purchase the property at the price which is contained in the BTA. To that, their defense is that contract has already come to it. There was no concluded contract between you and.
Where is that?
এটা কি? I had taken your lordship to page 190.
Yeah.
kindly, my lord, turn over 2 pages and come to 193.
Yes.
3. My lord, this is the mail of 28th May 2024.
Yes.
As you are aware, this is, my lord, their writing that we had entered into the business transfer agreement of 6 December 2023. This is the agreement which is our matter. In relation to our proposed acquisition of your business operating in Sector 1 in the name and style of Subway as a going concern by way of business transfer proposal. Under the terms of the BTA, the parties had agreed to consummate the proposed transaction upon satisfactory completion of agreed conditions precedent.
Yes.
So, in no uncertain terms, they says that it was proposed transaction which was supposed to be completed upon satisfactory completion of agreed considerations prior to entering into the agreement. The proposed transactions contemplated in the BTA was commercial in nature and its material and key components, including proposed consideration, even consideration was not finalized, were predicted on underlying data and information in relation to the business undertaking as at the time of execution of the BTA. The parties understood that time sensitivity completing the transaction since underlying data as on the date of execution would not truly reflect the affairs of the business undertaking the future. Given the above, the parties wished to complete the transaction at the earliest and furtherance of the same had explicitly agreed long-stack date of 26 December 2023 in the BTA, which was the last date of completion of CPS and closes of the transaction, failing which BTA was liable to be terminated without any liability to either party. As of this date, we note that the CPs condition precedents were not completed by the long-term date and have not been completed this day, and therefore the BTA stands terminated by virtue of the long-stop date. So therefore, my lord, he says that you have not even performed your part. That is to be gone into, my lord, with the suit, whether I was obliged to perform, whether he was obliged to perform. But the bottom line is, my lord, that there was no concluded contract even as per my learned friend.
Yes. Then?
So, my lord, therefore, I come before the court and say that this is a malafide stand. Ask him to sign the dotted lines. That is my defense. Specific performance would mean that. Now, my lord, once that dotted lines is not being signed, till such time it is not.
If it is a specific performance, what is your prayer?
My lord. Bolo. Will it kindly come to page 13, paragraph 36?
GA1?
GA1, yes, Will it?
Paragraph 30.
Yes.
Yes.
Declaration that the termination of the business transfer agreement in respect of such and such by the defendant is bad in law and liable to be set aside. It's by that letter. Declaration that the business transfer agreement 6 months in respect is valid and binding. Declaration that the pre-termination notice of 15th April 2024 is bad in law. This is, my lord, the first letter that I said. This is under the parent agreement. Decree for specific performance of the business transfer agreement of the store merchant such and such as agreed by the plaintiff and the defendant, number 1. Now, my lord, 2 causes of action are here. One is ask him to perform the BTA. The BTA which is before your lordship, my lord, 26 number to annexure K to which is my lord, lordship stays in the same page, my lord, page 127. Your lordship has the BTA agreement, my lord, of the same petition, my lord. Of GA1. I placed paragraph page 127.
127.
Annexure K? Is it volume 2? Oh, I'm sorry, Millard, it's volume 2.
GF 1 का वॉल्यूम 2 का है. Hmm. 127.
Yes, Millard.
Yes.
Millard, all I need to show to your Lordship, Millard, is page 187.
187?
Yes.
Yes.
Millard, your Lordship finds
187.
187. It looks like execution of page of business transfer.
Yes.
Yes. Millard, kindly see execution such and such between such and such. So this is the page where the parties are executing. In witness, the parties yet to have settled and subscribed the escrow hands in the first year. Signed by Eversub such and such, the acquirer, Eversub Limited. This was not signed. I want him to sign this. So, whatever is witnessed over here in these pages from 120 to 186, Millard, is not being accepted by him today.
But they are not denying.
I am not.
They are not denying with regard to the execution of this agreement.
No,
And they are relying upon this agreement, and you, in the prayer, you are praying for the specific performance of this agreement. So the concept, the terms of contract will not come into force.
Millard, with respect, these terms and conditions contain three parts. One is what I am supposed to do prior, what I am supposed to do during, and what I am supposed to do thereafter. These were the terms and conditions. My learned friend is today coming and saying, irrespective of his letter at page 193, that it is no more there, he is coming and saying that I am not going bound by the business transfer agreement, but I am bound by the arbitration agreement. This is the only scope of inquiry today. Now, Millard, the arbitration agreement says, if your Lordship sees the arbitration agreement, once the arbitration agreement, the language is down on. Clause 14, Millard. এটাই তো Millard.
Yes.
This agreement shall be governed in accordance with the page 140, clause 14.
Yes.
Agreement shall be governed by the laws of India. Dispute arising out of this contract, subject to clause 14 below, the courts in New Delhi shall have exclusive jurisdiction to entertain. Very important. In the event of any dispute or difference between the parties arising out of or relating to this agreement, representatives of the party shall 30 business days notice in writing resolve the dispute such and such. So this agreement doesn't mean only the terms and conditions written down in pen and paper. It has to be agreed upon. Millard, it's like this, Millard. I agree to purchase his business. On principle, I agree to pay him 10 lakhs of rupees. He said very well. So in principle, there is an offer and an acceptance. Now the terms and conditions has to be within the dotted lines because this was an oral understanding. I give him the terms. That these are the terms you sign. one of the parties signs, the other party backs out of it. Question is there an agreement? If, my lord, I have not signed, suppose, my lord, I was in his place. If I have not signed the agreement, can he come and say that since you have not signed the agreement, the terms are in any event binding on you? So, my lord, it's my lord, if I may ask myself, parties have decided to put their negotiations in a written form. Once the negotiations are in a written form and that written form their parties do not agree to sign, then there is no contract. If there is no contract, so far as I am concerned, if I am aggrieved by his not signing, then I will call upon the court to, my lord, ask him to sign the dotted lines. Once that dotted lines are signed and an agreement comes into being, all terms and conditions covered by this agreement would be covered by that arbitration clause.
Correct.
If he doesn't sign and he does not want to be bound by or wants to buy my agreement,
that is not the case.
So there is not the contract.
No, that is not the case. We have not signed.
Yes, he is not signed.
Where is that?
Well, that is why
not signed the document. But as per contention that they have not denied with regard to the agreement.
No. Well, existence of BTA is not denied.
Correct.
Now BTA is a blank sheet of paper containing certain terms.
Correct.
He says there is a BTA.
Correct.
I am saying there is a BTA.
Correct.
I am saying that the BTA is binding on him. He is saying no, the BTA is not binding on me.
No, not. Where from you got that the BTA is not binding him?
Well, Lord, kindly.
Where from you are getting?
193.
193, yes.
193, last page. It is his letter.
Yes.
As of this date, we note that the condition precedents
were
not completed by the long stop date and have not been completed to this day. Therefore, the BTA stands terminated.
Terminated.
How can he terminated means that he doesn't, that offer of his to purchase the property, the offer of his to purchase the business is being withdrawn. He had given me an offer. He said that you buy it within 10 days. If you don't buy it within 10 days, I'm withdrawing it. So, Millard, if I may ask myself this question, where is the contract? He's just withdrawn the offer. He offered to give me purchase my business. He now is withdrawing the offer. To form a contract, you would have to show that this offer was accepted and thereafter there was a breach.
So, as of this day, we know that condition precedents were not completed by
the long stop date.
And you have not completed to this. So, he is making allegation upon you. You have not completed that. That's why he is going to terminate.
Now
or terminated, whatever it may.
Yes.
Correct. If it and contrary, you have praying for this court, challenging this letter to come for the specific performance of contract.
Willard, it's like this. Willard, I give an offer to my learned friend to purchase my house, say for ₹10. That agreement, I give it to him, saying that you sign it and give it to me because that would record a concluded contract between the parties. And within that, there is a term that in the meantime, you will make out a marketable title. My learned friend is under an obligation not to make out a marketable title till such time this concluded, because this conclusion of his obligation to make out a marketable title will depend upon there being a contract. I am saying, so far as this long-standing stop gap is concerned, Millard, this clause is not binding on me because you have not signed the dotted lines. There is no concluded contract between us.
Okay.
So therefore, today you are saying that you have not performed the conditions precedent.
Yes.
Now the condition precedent to be binding on me has to be in some contract. That condition precedent is part of the BTA, which BTA was never signed between the parties. So, Millard, to make a obligation binding on me, he will have to show that, well, there is a contract between you and me. How can there be a breach of an obligation when there is no contract?
So if it is not, if they have not signed,
They have not signed.
correct?
Yes.
And the BTA is not a concluded contract.
Yes.
So how your prayer of A and B, A will be maintainable on the parent?
Millard, one line answer, Millard. Question is, now that your lordship is going into the merits of the matter, question is whether I can compel him to sign these lines. If I can compel him to sign these lines, I will have to show under the specific relief act that on merits I am entitled to specific performance of this agreement. If your lordship gives me a decree that no, you had agreed to purchase it, you sign the dotted lines, and from now on you continue and perform. So once that dotted lines are signed, then at my instance, to a decree of court, all disputes thereafter between the parties would be governed by the arbitration agreement. Because then the arbitration agreement will take shape. He has binding obligations in writing. I have binding obligations in writing. And the court has said that your withdrawal from that, from signing those lines was not proper. I have run to court. That was one of my causes of action. My other cause of action, which is the more urgent one, is till such time your lordships do not take a call on this, that whether the BTA is binding or not. Under the parent agreement, which is not the subject matter of dispute, he is trying to terminate it. So he is trying to now force me. And there is a prima facie finding that that was not proper. So therefore, that part of the cause of action, Millard, in any event cannot go to this arbitration.
Okay.
So that comes my second point, that if my causes of action are bundled together and it cannot be bifurcated, one leading to the other, then Millard, the courts will not refer the parties to the arbitration. Because that arbitration agreement is not with him, it is with another who has not come forward to challenge it. This is my second argument. Millard, give me 10 minutes any day. I'll just need to, Millard, 10 minutes any day. Tomorrow or day after, whenever. Around Tuesday? Any day, Millard. Any day. Tuesday, 3:45.
3:45 is the bank.
Tuesday, 3:45 again.
Tomorrow, 3 p.m. Tomorrow, 3 p.m.
No, tomorrow I have.
Millard,
I'm not been able to complete. I cannot dictate.
No. Both the parties have to Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff has argued at length in reply to TA2 of 2024, but due to paucity of time, hearing could not be completed. This is the matter.
First Monday's holiday.
कब है? नहीं है. 11:30 कुछ नहीं है.
There's a long weekend there. Tuesday is the first day next week.
Huh?
1st April.
1st April. है क्या उस दिन वो है ना कमर्शियल है ना 1st April 11:30.
Whenever. 28th interim order expired. Millard, the interim order is expiring on 28th.
When?
28th.
Counsel for the plaintiff submitted the interim order granted delay is going to expire on 28th of March 2025, and accordingly pays for extension of interim. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 8th of April 2025 or until further order which is
Look, there is another matter.
Yes.
Item number 29 today. This also deals with a similar kind of a, but It's only on the NBIU. My lord,
Okay, let me continue.
if my lord pick that also on Tuesday, then my brief counsel is coming from Delhi. It will be easier for him to.
But on that day, the first matter will be completed.
Yes, my lord.
Okay, कौन सा matter है? 21.
Item number 29 today.
29. Commercial. That also. मनु तो उसको भी साथ में रख लो.
My lord,
आगे पीछे में रखो.
my lord, mine is item. May I have your lordship's kind leave to mention, my lord, item numbers 33 and 34.
Just one.
Yes, item number 19.
Item number 29, which your lordship has listed. There also, my lord, 28, the entry model is expired.
28. उसमें भी entry model करते हैं. 29.
So an order may be passed. That matter also, fortunately, the councils have said.
Be extended till so. List the matter on 1st of April at 11.
Well, item number 19 of commercial list, Your Honor. That is running for last 3 months. If a specific time may be fixed. A specific time, as per the convenience is honorable court, Your Honor. Item number 19.
Item number 19.
19. It is running for last 3 months, but it is not reaching. So any time may be fixed, Your Honor. Anytime, as per.
Time, then you have to go to the June after summer vacation. You will get the time, then only. Because now the item number 17 is over, then your number will come in the urgent motion at the top. Friday it will come at the top.
Much obliged.
Yes.
May I have your lordship's kindly to mention items 33 and 34 for extension of entry mode is expiring today.
Yes, my lord, I appear for the respondent, my lord. I appear for the respondent. 33 and 34.
33 and
Commercial.
34.
But 33 and 34. When it is going today?
Today.
Sense offering for the petitioner, sense offering for the respondent. Counsel for the petition submitted. The interim order granted is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff and petitioner, the interim order granted earlier is extended till 22nd of April 2025 or until further order, whichever is obtained.
Grateful to Lord.
33 and 34.
Lord, item 100 interim order is expiring today. It's of the non-commercial list, my lord.
Non-commercial?
Yes.
106.
116.
116.
On notice, I'm
non-commercial matter. So offering for the plaintiff. None appears on behalf of the defendant, though the counsel for the plaintiff has issued notice to the non-advocate on record of the defendant. Police counsel for the plaintiff submitted interim order granted earlier is going to be expired today and prayed for extension of the interim order. Considering submission made by the counsel for the plaintiff, the interim order is extended till non-commercial?
Non-commercial, my lord.
Till 24th of April 2025 or until further order, whichever is there.
A matter to be there in the list.
Matter will remain in the list.
Much obliged.